Good afternoon to the presenters that are here with us today, as well as to the staff of the Legal Practice Council. We welcome you to today's preparation session for the upcoming August exams that will be taking place next week, Tuesday and on Thursday. Candidates, we thought that it is prudent for us as the Legal Practice Council to have our examiners to come and prepare you for this upcoming examination. We have 4 papers that will be written. Although all of you will not be writing all 4 papers, you have a selection of which papers you want to write. To get with me today, I have Mr. Thomas Mini, I have Ms. Vanessa Johnson, Ms. Hajira Kara, and Ms. Unipa Tawa. But before they start, they will also introduce themselves. Just for housekeeping rules, please be made aware that you will not be able to ask questions via a mic. However, there is a Q&A where you can type your questions in. And at the end of the presentation, or before the end of the session, the questions will be read out by Mr. Litebele, who will then give the speaker on the specific paper an opportunity to answer your questions. We just want to make you aware that this session is recorded and will also be made available. The recording will be made available on YouTube. And if there's any other questions that you didn't get a chance to ask during this session, you are more than welcome to send an email to myself at info@lpc.org.za, where we will answer your questions. Good luck, candidates. We know that you have prepared for this examination. The fact that you are even here means that you are dedicated to this, your studies, and we know you will do well. Thank you very much. I hand over to Mr. Thomas Mini, who will be doing paper 1.
Good afternoon to all the candidates and welcome to this webinar. I have to reiterate what was just said by Ms. Kwakcha, is that the fact that you are here present at this webinar shows your dedication to want to succeed in the upcoming exams. So we are here to assist you as best we can, and I trust that you will find the information given to you valuable for your preparation. I'm going to turn off my camera and I will only be on the microphone. Okay, so the first paper that you will be writing will be the paper High Court Practice and Procedure. It will contain Magistrates Court Procedure, Criminal Court Procedure, as well as motor vehicle accidents. Now, in respect of the paper that you're going to write, paper 1, I just want to start off giving some general information. Candidates must remember to carefully read through the instructions provided on the day of the exam. Also, please note that no information or answers which are recorded on the left-hand pages of the answer script will be marked. This is extremely important, as it has now happened on numerous occasions that candidates record answers on the left-hand pages and the examiners are simply prohibited from marking those pages. So please write on the right-hand side, follow the instructions in the answer book themselves. The exam must be written in black ink only, as answers recorded in any other alternative color ink, as well as pencil, will not be marked. Candidates, please, if during the exam you experience any difficulties with regards to your pen, it stops writing or something happens, whatever, please just put up your hand and call the exam official for assistance. They will assist you and give you further instructions with regards to the issue at hand. Then lastly, with regards to just general information, is candidates are given time to peruse the question paper prior to commencing with answering the questions. This is extremely important. Make use of this time and read through the question paper. As we have seen that candidates on numerous occasions answer questions only to realize that the answer relating to the question asked further on in the exam paper, and then the candidates have to go back and change the answer or renumber it, and the question paper starts looking, excuse me, rather dismal. So please read through the question paper. What also happens is when you read the question paper and you go through it, the juices, the gray matter juices start working, and you're in a better position to answer the questions when you do start writing. Okay. Then with regards to the approach which you should adopt when answering the questions themselves, when reading the question, identify the facts contained in the question which are relevant and which are contained in the question for consideration by the candidate in order to test their knowledge on the specific aspect being examined. Remember, certain facts contained in questions are there maybe as a red herring. It is there to test whether you can understand which are the relevant facts and which facts are irrelevant. Remember, you must keep in mind that when a client arrives at an attorney's office, all the information they give them may not be relevant to the specific case. It is for the attorney to sift through them and to figure out what's relevant. Okay. If you need to, here's another piece of advice. Dismantle the question into components. It makes it easier to identify the facts that are relevant for the question being asked. Another important change that's taken place in this exam for paper 1 is that there are no half marks. In past exam papers, there were half marks given. There was a decision made that there are no half marks, and therefore candidates must pay attention to what the mark allocation is, and marks will be allocated 1 mark per relevant fact that is required by the examiner. There is also no marks for yes and no answers, and marks are only allocated for the motivation of your answer in order to demonstrate to the examiner that the candidate displays the relevant understanding and knowledge of what is being examined. Okay, keep your answer limited to what's being asked. Don't waffle. Keep your answer as short as possible, but yet with enough information that the examiner may draw the conclusion that the candidate knows what is expected from him and that they display the relevant level of knowledge. Then, moving on to the specifics with regards to the High Court practice and procedure. In both the High Court as well as the Magistrates Court procedure, a candidate will be expected to display a competent level of knowledge relating to the rules of court. Please, it is most important that you understand that the civil procedure in the South African legal landscape is run primarily on the rules of court. If you do not know your rules of court, you cannot expect to be successful in this exam, or at least in these 2 components of that exam. You must understand how the rules of court plug into each other and when and where they are used. Again, in respect of the rules of court, the candidate needs to demonstrate an understanding of how the rules are applied, as well as when such a specific rule may be applicable in specific circumstances and when provided with a specific set of facts. Remember, the exams, if you had the ability to read some of the past exams I know they don't distribute past exam papers anymore, but it's always the same. Set of facts is given, and from that, they ask what document must be prepared. And what they're looking for is some notice or some document which is prepared in terms of the rules of court. Those documents normally are not very elaborate, but they contain very specific issues that needs to be brought to the attention of the opposing party. So you've got to have knowledge of how those rules interact with one another. A candidate will also be required to draft certain of the documents relating to rules of court. And therefore, it is important to study the form in which such rules of court are recorded. In other words, what is it? Is it a notice? If it's a notice, what does the heading look like? What is written between the lines where the notice is? What type of notice is it? Does the notice require you to act, or is it just a notice for information? Okay, and again, applicable to a certain set of facts. A common mistake observed during the evaluation of the exam scripts has been that candidates fail to demonstrate an understanding between application proceedings and action proceedings. These are basic skills without which a candidate cannot expect to pass this exam and be admitted as a practicing attorney. Candidates must ensure that they are well versed in the different processes as well as the forms in which these processes are conducted with reference to the parties in these processes. Ladies and gentlemen, we observe it all too often when marking these papers that candidates still in an action proceeding will refer to a party as an applicant and a respondent. That is just unacceptable. You cannot at this stage and your level of expertise make those kind of mistakes. You are penalized for that, and those are simple marks that get thrown down the drain. The South African landscape operates on two primary processes. It's the action proceeding and the application proceeding. You have to know what they look like. The one is by way of notice of motion, the other one is by way of a summons. What is attached? Affidavit, particulars of claim. Who signs? Deponent, affidavit has an ending. What does it look like? Summons, who signs? Attorney, what does it look like? What does a notice of intention to defend look like? What happens when you don't defend? What happens when you do defend but you don't plea? And so you build up and you build up, and if you answer those questions one after the other, you can see that now you are answering the questions relating to the process of the rules of court. But you cannot, at this stage, want to have an affidavit signed by the attorney. It's not the attorney who's signing the affidavit. It is the deponent. It's the party. The court doesn't want to know what the attorney has to say. They want to know what the person who's making the affidavit has to say. So don't make those mistakes. The other thing that we find often is that candidates do not know who the various role players are with regards to the courts. How do we refer to the administrator in a high court? He's known as the registrar. And in a magistrate's court, it's known as a clerk. You find all too often those two are mixed up as well, and it's once again simple marks that get lost. Okay, so candidates will be expected to display their knowledge and understanding of the affidavits used in application proceedings, as well as the circumstances under which the various affidavits are used. So what do we find? We find the founding affidavit, find the answering affidavit, we find the applying affidavit, we find a confirmatory affidavit. All those affidavits must know when they're used, how they're used, and by who the affidavit is made and which one is given after which one. So understand how they fall in the process. Then in both the High Court as well as the Magistrate Court procedure, candidates will be expected to draft pleadings, and as such, candidates must ensure that they are able to draft the headings of pleadings, the contents of the pleading itself, as well as the ending of the specific document. We find all too often that we deal, or the question relates to an action proceeding, and then we find here comes an affidavit. That belongs to emotions. And then it gets even worse. Then the candidate is the attorney is the one who signs the affidavit. It's just simply incorrect. So make sure you understand by whom the document is compiled and what the purpose of the document is. Okay. Candidates must keep in mind that as an attorney, you may be required to act for either an applicant or respondent. That's if you're now dealing with application proceedings. Or you may be asked to act on behalf of the plaintiff or the defendant in circumstance, in action proceedings. And therefore, the candidate must be able to display an ability, an understanding, by way of the relevant document which is applicable to the specific circumstances. So if you're acting for an applicant, you must be able to draft the document from the applicant's point of view. If you're acting for the respondent, you must be able to draft the document in response to the application received by your client, who is the respondent. You must understand how the rules of court relate to the applicant and the respondent. Certain rules of court are initiated by the applicant. Certain rules of court are initiated by the respondent. And certain of them demand answers either from the applicant or the respondent, depending on which party has the right to request information. Always done by way of rules of court. Okay, then candidates must also understand the procedure followed during a trial. Now, when we refer to a trial, we refer to the process, including the process followed in the run-up to the trial. In other words, prior to the trial. The process followed during the trial, as well as aspects that may arise subsequent to the conducting of the trial. And just to give you an example, that may be not limiting to, but may include aspects such as reviews and appeals. So the trial may not be over when it's over. There may be aspects that need to be addressed afterwards, and you have to know them. It comes up all too often that questions are asked on appeals and reviews, especially the difference when you can use which one is used, and what the grounds for a review and an appeal is, because they are different. It will also be required from candidates to display a competent understanding of aspects relating to urgent applications. Personally, this is one of my favorite questions, especially during the oral exams, because it's a unique application and there are very specific prayers and aspects that need to be included in such an application for it to be classified as an urgent application. So you need to know what the documents look like and under which circumstances they are brought before court. Okay, then as far as now you can see that the Magistrates Court and the High Court, to a large extent, the the advice that we're giving, they relate to both the High Court as well as the Magistrates Court. So when it comes to the different parties as well as the pleadings and understanding the processes, it relates to Magistrates Court as well as the High Court. The major differences between the two is that there are certain rules in the Magistrates Court which do not apply exactly the way they do in the High Court. And those, especially those rules that are different, are the rules that the candidate should go and study and make sure they understand. And then, of course, the jurisdictional aspect with regards to the Magistrates Court or the High Court. That's the other major difference between the two. And then we look at the aspect of citation. How do we cite the High Court? And how do we cite the Magistrates Court? Normally in the exams, you're asked to cite the Magistrates Court or High Court from one of the major centers like Johannesburg, Cape Town, Durban, etc. So it won't easily be one of the remote High Courts or Magistrates Court, but what is being tested? We don't need necessarily to know the exact citation. What we want to know from the candidate, does the candidate understand that the Magistrates Court, for example, may have jurisdiction relating to the complete cause of action or the address of the defendant? If you identify that from the set of facts and point us in the right direction, you will be allocated those marks. Okay, so it's important to understand that. That as far as the High Court and Magistrates Court procedure goes, and as I said, the procedures are mainly run with regards to run on the backdrop of the rules of court, and that will then include things such as expert notices and the like. Then, ladies and gentlemen, the component of the first exam where a candidate can really make up some marks is the motor vehicle accident claims section. It is not a lot of work to cover. It is, and it's not a difficult component of the work to understand. If you have a look at the syllabus, you will see the syllabus contains something like 12 components starting with the act itself. Then there is a component relating to the difference between the two acts for the 1996 and the 2005 Act, locus standi, causation, wrongfulness, fault, damages, contingency fee, apportionment of claim, drafting of the different documents, quantum of damages, and injury assessment and prescription. That's it. That is as far as it goes. I can assure you that because of the scope of the work, you will be required to know every single component of motor vehicle accident claims. There will be questions on damages, types of damages, quantum of damages, who can claim, citations of parties, who claims on behalf of who, etc., etc. I can guarantee you now that you will find in the exam. What you will also find in the exam relating to motor vehicle accident is the issue of drafting. It's important to know that you may not always be asked to act on behalf of a claimant. The examiner may also wish to test your knowledge from the angle of the road accident fund. In other words, you may be briefed as an attorney acting for the road accident fund, which means that then you 99% of the chance you're going to be drafting documents from a defense point of view. Then further with regards to motor vehicle accident claims, remember there's, like, as I said before, there's only so much that can be asked. The act itself is not voluminous, and if you just take it from the top and you start, the questions that you could ask in preparation is, under what circumstances may I claim? Who may claim? How do I cite them? What may I claim for? How do I go about claiming? In other words, what documents must be completed, by whom, within which period of time? Okay, so now you've completed the first component. You've answered all those questions, and in preparation for the exam, if you ask that, if you know the answers to those, you're already halfway there. Then it's a matter of what must the contents of the documents be that you're going to submit, and what happens when the road accident fund, for example, does not entertain your claim. What are the rights of the claimant? And then the last aspect with regards to motor vehicle accidents, it's contained in here, is the issue of the various types of fee agreements which you could find between attorney and clients relating to motor vehicle accidents because of the nature of the claim, where the attorney could act on risk. And you find that many of the claimants do not have the financial resources to pay attorneys upfront. So have them know about that, understand how it works. And what's also very important, before I forget, is the time frames relating to motor vehicle accident claims. Remember, those time frames are not all the same as normal civil litigation claims, where you find prescription basically in 3 years' time. So you need to know the different prescription time periods relating to claims unique to road accident fund matters. Okay. Then the last section that you'll be tested on will be criminal court procedure. Now, the criminal court procedure also, although it is quite a substantial amount of work, it is not a difficult section of the work to understand. Once you've read through the entire scope of work which is contained in your syllabus, you will notice that the criminal court component of this exam is what we refer to as substantive law. So what you find is that the documents and the sections relating to the criminal procedure gives rise to the drafting of certain documents. But the contents of those documents is basically contained in the Criminal Procedure Act itself. An example, before I get to that. What is important, candidates make a mistake. It's a continuous mistake that are made by candidates, and please take heed of what I'm telling you now. When drafting documents relating to criminal procedure, you must ensure that you understand who the drafter of the document is. You cannot, for example, draft a document where an accused pleads guilty in terms of section 112, and then it's the attorney who signs the document. The attorney is not pleading guilty. He is not charged. He has nothing to do with it other than representing the accused. Understand who drafts which document. Adversely to that is a section 114 application. Who drafts that document? for example, that document is not drafted by the accused. That document is generally drafted by the legal representative of the accused, who then asks, for example, for a discharge because they believe that the state has not proved their case. They ask for a discharge and return a verdict of not guilty. Okay, so as far as the criminal procedure is concerned, there is really not much to be said with regards to the contents of the syllabus, other than you have to go and study all of the relevant documents that are listed inside the syllabus. You have to know what a Section 112 statement looks like. You have to be able to draft it, including the headings, the contents of it, which aspects must specifically be addressed in that statement, and who must sign it. And the same applies, for example, for a Section 115 statement. And then with regards to the process itself, you must understand how the rights of an accused may be exercised in respect of the criminal procedure itself, taking into account the substantive law contained in the criminal procedure relating to delays, and as well as the constitutional right to a fair trial. That then, in a nutshell, with regards to the criminal procedure. I just want to mention one other aspect of the criminal procedure which I believe is important, and that there's actually two. Let me just go back a bit. The one relates to bail applications. Ladies and gentlemen, you have to understand the circumstances and the considerations which the court gives in bail applications. Now, when questions are asked on bail, most of the candidates understand the first component of bail applications. But each one of those tests, one of the tests raised in bail applications, then have numerous considerations that are given to such aspect. And it's there, that second tier, that the candidates seem to forget to study. Make sure you understand bail proceedings in its totality. And the next component that I want to just quickly mention is the aspect of sections 20 to 22, 20, 21, and 22 of the Criminal Procedure Act relating to searches and seizures. You have to know under which circumstances they are conducted and when such search and seizures may take place. That's a question that comes up quite regularly in the exams. So I trust that this has been insightful for you and that it will assist you. And I wish you all the best of luck for the exams. Margaret? Hello, Margaret?
Yes.
Thank you, Mr. Mini.
Kabelu, yeah, thank you. Okay.
Osmegi, would you mind that I go through the questions and comments, particularly those for Mr. Mini, and then we can also do more questions later? What do you prefer?
No problem, sir. You can do that.
Okay. Mr. Mini and other presenters, I'm just going to read what has come through so far in the chat. So the one question is for you, Mr. Mini, is Section 174 of the Criminal Procedure Act discharge drafted by an attorney?
Yes.
Okay. All good. Okay, there is one who's talking about difficulties connecting. So those individuals will be able to see the recording. Okay, there are questions about conveyancing exam preparation session that is scheduled for the 5th of September. The advocates one is on the 4th.
Cabello, can I quickly say this to the candidates with regards to this question that's come up now with section 174. As a general rule, candidates must keep in mind the following. When the document being drafted relates to conduct of the accused, then it will be the accused who drafts it. When the document being drafted relates to questions of law, then it will be the attorney who drafted it. In other words, that's why a discharge is drafted by the attorney, because it relates to an intricate understanding of evidence, how it was presented, whether the case was proved, and what the tests are. So as a general rule, if the candidates keep that in mind, it should guide them in which direction they should go.
Thank you, Mr. Mini. Another question for you, sir, is as follows. In citing legislative provisions or case law, how much detail is required? Is it full citation of the legislation as well as section and subsection numbers?
It was a decision made, and I speak under correction, Margaret can perhaps help us. There was decision made that no case law is required. We don't give marks for case law. There is one exception though, and that is the case of it's the Plascon Evans case. That is, as far as I am aware, that is the only case that is applicable to the current syllabus. Margaret, is that correct?
In terms of paper 1, that's correct, Mr. Mini.
100%. And then with regards to the legislation sections and subsections, you will be required to know the section and or subsection only to the extent that it is listed in the syllabus. In other words, if you are asked to draft, given a set of facts, and from the set of facts, you will then be required to draft a specific document. You will not be required to say, this is a section 112 document. You can say that it's a section 112 document, but you must know that a section 112 is an application or is a statement where the accused pleads guilty. That you must know. So the only reason that the section numbers are stated in the syllabus is simply to assist you to go and look where to find what you need to know for the exam. I hope that answers the question.
Thank you so much, Mr. Mini. Maggie, this one I think is for you. The question is as follows. This will be my first attempt at the exams, and I'm planning to write only 2 papers now, with the remaining to be written in March, that is 2026. However, I have heard that from next year there will be 5 exams in total. Would this mean that I will now have to write 3 exams in March instead of 2 as I had originally planned? How will this change affect candidates who still have 1 or 2 papers outstanding under the current structure? If you can get me us ready.
Thank you very much. The new syllabus for the candidate legal practitioners exam will come into effect August 2026. So if you are intending to write 2 papers now and you'll be left with the 2 next year, March, you will write the 2 that you have outstanding. However, the general rule is, even when the new syllabus comes in, You are required to write what you have not written, what's outstanding. So for next year, March, the LPC will still be running the examinations based on the current syllabus. The new syllabus will only come in August 2026. The LPC after these exams in September and in August will be running webinars concerning what to expect of the new syllabus. Thank you.
Thank you so much, Osmegi. The next two questions are more around structure, and perhaps Mr. Mini can come back in and reconfirm. The first question is, can we answer the questions in any order in the answer book? I understand that to be the case. Mr. Mini, could you guide?
Yes, you can answer in any order. The only thing that we require is that the questions are clearly marked.
Thank you, sir. Okay, let me see the next question. Okay, no, this is to do with other papers, but I'll read it out anyway. When would the LPC ever consider having clear and well-structured classes preparations for paper 1 to paper 3? Paper 4 is the only paper that has reliable lecturer to candidates. Please, can the LPC take care of us? Osmegi, I think that's more for your consideration. I'll let me look at what's also here. Okay, yeah, I think for now that is it. A lot of the other questions are more around the recordings and items like that. Just quickly looking at other. Oh, okay. Mr. Mini, I need you back on again, sir. There is a question here which says, when can I deliver a notice of intention to defend in a criminal matter?
When can you deliver a notice of intention to defend?
In a criminal matter, yes, that's a comment, sir.
The notice of intention to defend is delivered in a civil matter, not in a criminal matter.
Oh, okay, noted. Yes, so
then can I just quickly say I'm scared we just now we finished and I don't have time to say what I want to say now. That I see there's 908 candidates, or 900, just over 900 candidates on this webinar. Ladies and gentlemen, we and I'm speaking on behalf of my colleagues as well, I'm sure that they will agree with me. We are here to assist you. We don't want to fail and see candidates fail. That is not our objective. Our objective is to assist you and to ensure that we keep a certain standard. I know that candidates are scared to ask, or they're shy, or whatever the case may be. Please, if you have specific questions relating to the syllabus, I am available and I'm more than happy to assist you. I know there are challenges with regards to the levels of assistance you've had up to now, and there are challenges with regards to remoteness, etc., and so on. Please, my door is open. If I can assist you, I will assist you in any way I can. The only thing that you cannot ask me is what's in the exam, because unfortunately that question is never going to be answered. So please feel free to send it to Margaret. If the Legal Practice Council allows it, you can send it straight to me, to my email, and I will do the best I can to assist you.
Thank you very much, Mr. Mini. Osmegi, I would like now to move on to the next presenter. However, to the candidates, if there are still further questions and pressing questions for Mr. Mini, please do continue posting them. Before we close the session, we will again look at the questions and comments that you'd like Mr. Mini and all other presenters to respond to. At this point, I'd like to invite Ms. Johnson to come on and deal with the next paper. Over to you, Ms. Johnson.
Good morning, good afternoon, all you candidate attorneys who are going to be attorneys very soon, if not now, after this exam, hopefully next exam, or when you write all your examination papers. My name is Vanessa Johnson. I am going to just revise. This is not actually a revision session. I'm going to prepare you for the examination for estates next week. I'm going to put off my camera now, and now you can hear my voice. All right, I think most of you are very anxious and nervous at this stage. It's a week before you write the examinations. I speak from experience when I say that each of you only have two enemies. The first one is yourself, and the second one is time. Okay, now to get rid of yourself out of this picture, you have to study. The more you study, the more you know something, and the more you gain confidence to go and write the examination. The more confidence you have, the less nervous you are. All right. So my first piece of advice is really study hard. Don't just go through the work. Don't just read the papers. Don't just read any section from a syllabus or a lead notes or whatever notes you use. Please study them. Then for the time, to get rid of the time, you have to prepare yourself properly. Now, I'm going to give you some advice on how to get this nervousness out of your system and how to be prepared before you go and write an examination. And this is not only for estates, this is for all the papers. The cornerstone for success is to be prepared. To be prepared, you have to know your work and you have to write neatly. Remember, this is a written examination, so the neater your paper is, the more confidence you can deliver it to an examiner to mark it. Let's get back to the stationery you have to take with you. I advise you to take at least 3 black pens. You are only allowed to write in black pen and not in any other color. So no blue pen, only black pen. Yes, when your pen is out of ink, you may put your hand up and ask the invigilator to give you another pen, but that is going to take time. That is going to make you nervous. It's going to make you more anxious. So be prepared and take 3 black pens before the examinations. And make sure that they're all right. Then you can take a red pen or a highlighter if that is what you use to highlight or to take some specific aspects on your question paper to go back to at a later stage. You can take your pencil and your eraser if you also make notes on your question paper for that. You definitely take a ruler, especially for estates. You cannot go into this examination and not have a ruler. And then obviously you have to take your calculator. The thing with a calculator is, remember, most of us use our cell phones to calculate these days. Don't use that. Get out of that thing now. When you get a decent calculator, one that is not too difficult to handle. If you're used to a scientific calculator, that's fine. If you borrow or are going to borrow a calculator from someone, do it now so that you can get into the feeling of the calculator, and also obviously also make sure that the calculator works. All right, no writing on the left-hand side of the page, no writing in pencil, no writing in any other color pen than black, and no Tipp-Ex. I'm going to repeat that. You are not going to write on the left-hand side of the booklet. We are not going to mark that. Even if it is correct, we are not allowed to mark it. You are not going to use Tipp-Ex. You are not going to write in any other color pen than a blue pen, and you are not going to write in pencil. The pencil is only on your question paper if you want to make specific notes. All right, so that is getting into the location where you're going to write. You'll be prepared. Stop using the calculator on your cell phone now and start using the calculator you are going to use in the examinations. For estates, you are 100% assured that you will get the following subsections. You'll get wills, you'll get liquidation and distribution account, you'll get intestate succession, and you will have theory questions. Now, to go back to the wills, obviously wills and codicils go together, so you need to know all of that. You need to know the formalities of a valid will. So who can make a will, what makes a will valid, where does the testator and testatrix needs to sign, where does the witnesses need to sign, who can be witnesses, who can make a will. You need to know section 2 capital B, section 2 capital C, and section 4. So you have to know the theory of a will, what constitutes a valid will. And then you don't only need to know the theory, you need to know how to apply that in practice. Now, this is a practical examination, so they might ask you to draft a whole will, but you can't draft a whole will if you don't know the theory. So with wills, do not underestimate your wills, study your wills hard. You are definitely going to have a wills question. Usually the marks for a wills question is from 15 up to 25 marks. So be prepared for anything of those. Then together with the wills, you need to know massed estates. You need to know what is a massed estate. You need to know what governs a massed estate. And then obviously you need to know how a massed estate will be applied into a will. Once again, the formalities of the will, section 1 to 5, especially make sure that you know all of the sections of the Wills Act. I always say that when you have to write or you have to draft a will, you need a plan. Well, in any event, you need a plan to go and write this estates paper. So if you study your will, have a plan, set yourself a plan beforehand so that you can do that. Practice the will. Please don't just read through a will. Don't read through your notes and say, yes, I know this, I know this, I know this clause comes in, I know this clause comes in. Practice the will. It is especially important that you can write your theory question and your will question in a short period of time. I repeat, in a short period of time. The reason why I'm giving you the more or less marks it's going to take, I usually work on 1 mark per minute. So say, for instance, the will that you are going to have is for 15 marks. Set yourself 15 minutes for that, for the preparation of that will. Now you'll see once you start with it, it's not a lot. So how are you going to get rid of that time factor? You are going to study and you are going to prepare yourself to answer any type of wills question theoretically or drafting a will. The liquidation and distribution account, guaranteed you'll have a liquidation and distribution account. The marks for that is usually between 55 and 70 marks with an average of more or less 60 marks. Once again, if you see that you have a will of 60 marks, set yourself out a period or a time period of 60 minutes. Now, you have to study the liquidation and distribution account in total. You need to know the subsections of each account. You need to know that it starts with a heading and it ends with a certificate. You need to know Regulation 5.1, because Regulation 5.1 gives you the detail of what comes where. In other words, which sections follow up on each other, and what all the sections are that you have to have in your liquidation and distribution account. The other very important thing is, remember that before you write the examination, you have 15 minutes before that while you can read through your question paper. My advice would be, identify what they ask. Identify the wills question and say wills. Identify the L&D question and say L&D. Identify your intestate question and say intestate. And then the theory is obviously the additional marks, and that will be, that can be anything they can ask you. Then you go back. Now you've identified everything. Now you go back to your wills, and now you say, for instance, I have to answer a theory question on who may make a will, who may be witnesses. Just underline that or highlight that so that you know that this is what they're going to ask you. If it is something like draw a will, draw a will. Then look at the facts of the matter. What information do they give? Is it in community of property or out of community of property? Is it a mutual will or is it a single will? What do they want in essence? And then leave it at that. But read through the question very well at that stage. Remember, if you have to read a question paper of 100 marks in 15 minutes, you must be able to read quite fast. So I cannot emphasize this enough. You have to be able to do this fast. And the only way to be able to do it fast is by practicing it beforehand. The liquidation account, if you get the liquidation account, you see, all right, now you identify in community or out of community of property, testate or intestate. What do they ask? Do they ask me the whole L&D account or do they only ask separate sections? If they only ask separate sections, I'm only going to give them separate sections. Why? Because they're not going to mark the others and you're going to waste your own time. So read what they want. Then you go to the intestate question. Look at the intestate question. Just identify, yes, wife, surviving spouse, 3 children, 1 child is predeceased. More or less just the bones of the question. And then if you have time, you can go back and you can start deciding which question is the best one that you are the most confident with and start with that question. Or if you've planned during preparation that you're in event going to follow them in order of questions they give you, that's fine. If you decided you're in any event going to start with your liquidation and distribution account, that's fine. Just remember that you have to be in that 15 minutes, you have to prepare yourself on what you are going to start writing in your script. You are allowed to answer the questions in any order. We just prefer that then you clearly mark question 1 or question 2, question 3. We do see that it's a question 3 answer and we will still mark it. But just for your own sake, and I always say, remember, you never know which examiner is going to mark your paper. So make sure that any examiner can mark your paper. Mark your question. You are allowed to start with anyone in any order. Another tip I can give you is to start each question on a separate page. If you have a will, answer the will questions and leave open, say, 3 or 4 or 5 or 6 pages for everything you want to add with the theory and whatever they ask in the wills question. Then you start with your liquidation distribution account. Leave open 10, 11, 12, 13 pages if you want to. And then if you want to go to your intestate question, start that on a new page. If you think, all right, you're going to need 3 pages for your intestate question, leave open the 3 pages and then start with the theory questions. The reason I say leave open the space is so that when you have time and you're done with anything, or during the time, sometimes you remember you can say something about another question, then you still have space where you can do it. I always say that this is the one gift the LPC gives you next week, and that's a script with enough papers. I've never seen a candidate write any script from the beginning until the end. You have more than enough pages to do that. All right, coming back to the liquidation and distribution account, you identify what they ask. Then you have to practice it in writing. Once again, I emphasize this. Don't think that you know the headings of the subsections. Don't think that you know what is going to be or that what has to be reflected in a heading or under the liquidation account, the assets, immovable, movable, claims in favor of the estate. Don't think that you know it. You might know it. It's a different ballgame in the examination if you have to do it. I also know that many of you study by doing it on your computers or your laptops. Stop that. from now on, because in the examination you are going to do it with a black pen and a ruler and your piece of paper. So make sure that you are prepared to do that in the examination. You have to know every section of the L&D account in the specific order. If you want to use a new page for each one, that is 100% fine. If you say, for instance, you use one for the heading, and then you turn and you go to the liquidation account, the assets, and you use one for the immovable property, that's fine. The next one for movable property, the next one for a claim in favors of the estate, or any way you want to do it, that is fine with us. We don't penalize you because there is a space left open after a specific entry. The reason I advise that is that when you realize you've done something incorrectly, that you can draw a neat line through it. Remember, you're not allowed to use Tipex. You're not allowed to write in pencil. So you are going to write it in pen. If you realize it is incorrect, you take your ruler, you draw a neat line through it, and you have some space to redo it. This is just tips to make it easier for you in the examination, but that's the way that you have studied is fine, as long as we have a liquidation and distribution account at the end to mark. The one thing, and Mr. Mini also said that, there will be no half marks in this examination. I repeat, there will be no half marks in this examination. And although I can say that this is not a difficult paper, this aspect might make it a little bit more difficult. So, for instance, if you have an asset, you need to identify the asset correctly. So look at your question paper, see how they identify the asset, and then you use the same information. Then the amount you use for that specific asset or liability, whatever it is, has to be the correct amount. So in the past examination, we gave half a mark if the entry was more or less or was correct, and a half a mark for if the amount was correct. This time it's not going to be that. So if the amount is correct, we are going to look at the entry and the definition or the description of what the asset is. And if those two aren't correct in total, you are not going to get any mark. So please make sure that you read your paper. That's the most important thing. Read your paper, read what they ask you, and read how they identify or describe any asset or liability. Please also don't do this. Take a chance and just write all the assets down and amounts down and think, oh, well, we're going to mark whichever is correct. We'll see that you don't know how to do a liquidation and distribution account. And I always say that if you do know how to do the L&D account, you won't just take a chance on that. So once again, the entry, the description of the asset or the liability, as well as the amount, has to be correct for a mark. If both are not correct, you won't get any marks for that. All right, I said you have to study regulation 5.1a to I. I trust by now you have studied it. I think by now you should have been able to understand the L&D account. You only have to practice with examples on a piece of paper and with your pen. All right, then the intestate succession, as I said, during that 15 minutes, you go through the intestate succession, you see what they ask, highlight the surviving spouse, highlight the children, highlight the mother, the father, the brothers, the nieces, the uncles. If you are familiar to draw your spider web, that is fine. You can draw the spider web in the 15 minutes before the examination starts. On your exam paper, we are not going to mark any webs. we are going to mark what you take from there. So my advice for the intestate question is that you always start by looking for the net value of the estate. Usually they give you the net value, or sometimes they give you the assets and the liabilities, and then you need to know that you have to subtract the liabilities from the assets to get your net value, and the net value is the amount that has to be distributed. Then you identify, is this in community or of property or out of community of property? So then you apply that principle of in community of property if it is in community of property. Then you are going to go to who is the surviving spouse, or is there a surviving spouse? Obviously, if it's in community of property, but for out of community of property as well, is there a surviving spouse and how many children? So now you apply that principle, the principle of 250,000 or a child's portion, whichever is the greater one. So don't assume that the examiners know that you know it. You have to write it. You get a mark for saying that. So whatever you think, you write down. Then after you've done that, now you identify the heirs. Now you name the heir. You say exactly what he or she inherits, and you give the reason why. The reason obviously is the clause or the section of the Intestate Succession Act. Then lastly, don't forget this, because we do mark this. We do allocate marks for this. Now you are going to say who is not going to inherit anything. You are going to say someone is not inheriting and the reason why it is so. So the intestate question, before you can do or start dealing with any intestate question, you have to study the Intestate Succession Act. It's not a difficult act. We often in examinations as markers see that students simply don't study the intestate succession. We do not ask difficult questions for intestate succession. It is very, very simple and straightforward. But if you don't know the act, you are not going to be able to answer the question. Remember what I've said with the wills, is with the L&D account as well. It's the same with the intestate. You have to know the theory, and then once you know the theory, you must be able to apply it to any scenario they give you. Then lastly, you are going to have a theory question or theory questions. Well, they usually come from the process. You have to understand the administration of estates process. What happens when to and how when to do something, what happens when and how to do it. So in other words, when to do what, the whole process, and when I do what and how I do it. So once again, you need to know the theory and you need to know how it is done. In other words, the application thereof. For instance, the documents, you need to know which documents you're going to lodge. You need to know what you are going to do with those documents, what the master is going to do, what you do after you receive your letter of executorship letter. Then what happens then, which advertisements you have to place, where you place the advertisements, why, what the act says. So study those. And then if you can't lodge your L&D account in time, you need to know that. Then you also need to know what happens after you have done your L&D account and the master says, well, everything is fine, now you can pay it out. I've made a huge note here on my notes. Read. I cannot emphasize that enough. You need to read the paper. You need to read your questions. You need to see what they ask and identify what they ask so that you do not answer an incorrect question or that you answer something that was not asked. Then the recording for this session will be made available probably on Monday. I advise you to go over the weekend, apply the tips and the information I've given you now. and then re-listen to everything on Monday. It's not, the more you hear something, the more it sinks in. The more it sinks in, the easier it's going to be able, you are going to be able to do it in the examination. And then I really wish you luck. But luck is not really necessary if you have studied hard. I guarantee you, I really guarantee you that if you have studied for this examination paper, for estates, you will definitely pass the paper. All right. Do you want to just give me some questions I need to answer? Cabello?
Thank you, Ms. Johnson. Yes, please, if you can stay on. I'll just run through them and you can guide me on how you want to respond to each one. Let me start with the first two. What happens when there is an interstate succession in community of property, but the surviving spouse has a will?
Okay, let me answer that one first. I want to emphasize that this is not really a revision session. It's more a preparation session. If you ask a question like that, I want you to go back to the basic principles of the Intestate Succession Act. It has nothing to do with whether the surviving spouse has a will or not. It's all regarding the deceased. So the inheritance will devolve in terms of the Intestate Succession Act, but it will be the deceased estate. I hope I've answered that question.
Thank you, Ms. Johnson. I think the second one is also similar. You can tell me if you've already answered it. It says here, good day, does the child's share also apply to spouses married out of community of property?
Yes, I want to, from these questions, I've done a lot of classes lately during the past few weeks, and I know exactly what students battle with. If you ask me a question like this, you really do not understand intestate succession. So go back to the Intestate Succession Act. It says the deceased's estate will devolve in the following order. It doesn't say if the deceased was married in community of property, child share will be applicable. If the deceased was married out of community of property, the child share will be applicable. It says if the deceased was married, a child share will be applicable. Child share or 250,000 or not. So go back to the drawing board, go back to the basics, understand exactly what the sections there say, and now you'll see, all right, I've got a deceased person. I know that this estate is a mutual estate, a community estate, because they were married off in terms of community of property. So now I need to take half out. That is why we identify the half in terms of the marriage of community of property. Once I've taken out that half, the act applies. It now says that the deceased half will devolve as follows. And what does it say? If there is a spouse and there are children, the child share or 250,000 will be applicable. All right, so my answer, I think I've answered that one now, but in general, I want to really urge the students to go back to the principles of the Intestate Succession Act. Do that. You are definitely going to get an intestate question, and it's not a difficult act. Summarize the act, summarize the major parts of the act and study those. Once you know that, practice them with examples. All right, Cabello, the next one.
Thank you. Thanks, Ms. Johnson. Let me see here. In the 15 minutes reading time, can we make notes on the exam paper?
Yes, you are allowed to make as many notes as you wish, but not on the script. You're not allowed to write on the script, but I advise make as many notes as possible during that 15 minutes on your question paper.
Okay. Ms. Johnson, I'll just read it as I see it, and then you'll guide me as to whether or not, it's a matter of just revisiting the study guides and necessary information for the
Okay.
exams. Okay, it says here, hi ma'am, my first question is, when it comes to describing an asset, particularly immovable property, usually the question would state, and the person does give a number, House 21 Fairfield Street, or something similar. She says, I've always included the address in my description, ERF registration division. Is this acceptable when considering mark allocation?
All right, Cabello, let me answer that one. I'm very glad that you've asked that question. This is a very important one. If you have an immovable property, you can't just say house so-and-so and where it is located. You have to give us the detailed description of the house. You have to give us a deed service descriptions of the house. So a deed search description. So my advice usually for students is go beforehand, take one or two examples from previous papers or go to any study notes you have and see how they describe a municipal property, how they describe a sectional unit property, and how they describe a farm property, and study that. Because in the examination where we say assets and we say the value of or the proceeds of a fixed property, it has to have a detailed description. You will get a mark for a detailed description. You will not get a mark if you only say house situated at a specific address. You need to have the property description. You need to know how big the property is and the registration number. The regulation 5.1 actually also says that you need to give the date of registration of the title deed. So go back to your deeds officers sections in your conveyancing sections if you are an article clerk in a firm, or if you're not, go to your notes and identify descriptions of a normal property, municipal property, sectional title property, as well as a farm property. All right, Cabello, what's the next one?
Thank you, Ms. Johnson. I think we may have answered this one. I'll read it anyway. May I draw the spider net on the left-hand side of the answer book, or must it be left blank? I understand people cannot write on the left side of the answer book.
Okay,
Please guide me.
Let me just clarify that. You are allowed to write on the left-hand side. So if you draw your spider there, that's no problem. If you make any notes, you know how you study the order of the liquidation and distribution account, and you have rhymes and very funny business. How do you remember that? It's fine if you write that on the left-hand side. We are just not going to mark it on the left-hand side. So when I say don't write on the left-hand side, I mean don't write your answer, which you want us to mark on the left-hand side.
Thanks, Ms. Johnson. The next question is, when doing a distribution account and there is no will, the marriage is in community of properties and there are heirs. If the estate has enough funds, do we also have to show that the heirs are awarded their share in terms of, and here they say section 1(1)(c)(2), and award them? I don't know if that makes sense to you, Ms. Johnson.
I think without giving a revision, I'm just going to give the detail of the distribution account. Remember, the distribution account, the purpose of the distribution account now is to see who the heirs are. The purpose of the liquidation account was to see what the assets and the liabilities are and to determine the balance for distribution. Now in the distribution account, I have the balance for distribution, and now I'm going to award it to a specific person. And now you have to look at the act and see how that specific person needs to be described. Then I also need to say in terms of what. So yes, you have to say the section of the Intestate Succession Act if there is no will. And then lastly, you are going to say of what it consists of. So it's awarded to, in terms of, and consisting of. If I understand the question correctly, I think they want to know whether they need to put in the sections of the Act. My answer usually is, if you studied your Intestate Succession Act, you know the section, and then you can use the section.
Thanks, Ms. Johnson. I'm going to then handle the next two questions together. The first one is, if there are no half marks and you make a mistake earlier on, like in the liquidation accounts, will your totals be marked as incorrect thereafter? So as you receive no marks at all for the total gross assets, or are the following totals calculated based on this amount? Don't know if that makes sense to you.
Yes, I'm going to answer this as follows, that when we mark, or when we draft the memorandum, we do not allocate marks for the totals. If we do, it is for one or two, say for instance, the balance for distribution. So if you've made a mistake in your liquidation account, yes, your balance for distribution will be incorrect, but that won't cost you more than one. I cannot even say that it will cost you 2 marks. Usually for the total assets, for the total liabilities, for the totals in your recapitulation statement account, we don't give marks for those. We don't allocate marks for those. We allocate the marks for the specific entries, meaning the assets and the liabilities. So just let me emphasize once again, if you've made a mistake there, you won't get the mark, not even a half, but you will not lose a mark for the total assets, because we don't give a mark for the total assets. It might be in the balance for distribution, we might give a mark there for the balance for distribution, and there you might lose your mark.
The next question is also along the similar lines. If a certain asset or liability is omitted by the candidate, will the marker go from there, or will they be marking the rest of the LND as wrong? I think you've already answered it. Would you like to anything?
I want the candidates to know, our future attorneys to know this, that you won't, if you've made a mistake, it's not the end of the world. You've made a mistake. It's just the fact that you won't get that mark. You have more than enough entries that you still have to do in your liquidation distribution account to get all the other marks. So if you look at the liquidation and distribution account, we give marks for each and every entry. So if you lose that, we don't allocate marks for the totals. You will still get your marks for the rest. We don't stop marking it. We don't mark with your mistake. We don't penalize you. We just go on and see and look for the correct entries.
Thanks, Ms. Johnson. The next question is, with regards to the liquidation and distribution account, how do we deal with public company shares in the estate duty addendum, if at all?
Okay, that is now a revision question. I don't think this is the platform for me to explain that now. I'm really willing to explain it to anyone, but not on this platform. So you can reach out to Ms. Kwake from the LPC, and she can maybe forward me the email so that I can answer that. Or I always say, just go back to your notes. It's very clear there, but unfortunately, I don't think this is the platform to answer that question.
Thanks, Ms. Johnson. Okay, let me see the next question. Okay, there is a connection issue, but I do remind the candidates that the recording will be available on Monday. Let me move on to the next question. Okay, no, this has been asked. Are we allowed to make our small notes or reminders on the left-hand side of the answer sheet?
Yes, you.
Yeah. Okay, let me just do the next one, and you can respond. Can the estate duty addendum be done immediately after the liquidation account? Are you able to? Is that a revision question?
I'll answer that one. I always say that if you know Regulation 5.1, you know that it can't be done just after the liquidation account. I do think that some teachers teach you that, because in practice we actually have to do it. We have to first do the L&D, the liquidation account, and then the estate duty. We won't penalize you for doing that. But if you know the act and the regulation, you know it should not be done after that. We won't penalize you if you do it.
Thanks, Ms. Johnson. The next question is, what if we leave open spaces in estates? However, we do not finish. Will we be prejudiced if we answered on page 3 and then again on page 14 if we did not finish? Or do we need to draw? Then a line through those we did not use in between?
Remember, you don't have time to draw unnecessary lines. Your task is to prepare your answer sheets or your script so that it's easier for you to do it. So if you've answered something and you stopped on page 3 and you only started on page 14, it is our task in the examination to look through the whole script. We look through the whole script to see whether there is something on other pages, and we will draw the lines through the pages you have not used. So don't worry about that. We will look for your answer.
Okay. I'm looking at the next questions, which you've already answered. They refer to errors in calculation and leaving spaces. So let me look at the next question. Asmegi, this one might be for you. One candidate says, this is my first attempt ever. What happens if I get a 49.5%? Do I get an oral or exam, or will it be rounded up to 50?
Thank you, Butikabelo.
Okay.
The general rule is that from 0 to 39, it's a fail. From 40 to 49, it's an oral. 49.5 still falls under an oral. Thank you very much.
Thanks, Asmegi. Let me see the next question. Okay, this is a general question. Hi, would you recommend doing the L&D first and then the theory, or the other way around? Don't know if you've got any comments on that, Ms. Johnson.
I suggest that you do whatever you're best at first, but within your time period. I forgot to say that. Thank you for asking that question. If you do your, say for instance, you do your L&D account first, and the L&D account is for say 60 marks. So after an hour, you see that you're only halfway with your estate duty, or you have not even done your estate duty. My advice now is to leave open the space for the estate duty and start the next question. Say, for instance, the next question is your intestate question. Start with that one, because from experience, I've often seen this. There are more marks in the beginning of a question than at the end of a question. So probably when you get to the L&D question and it's after an hour and you still have to do the estate duty, you obviously battle a little bit to get through everything. Leave open some pages, start with your next question, do the first part or until your 15 minutes or your 20 minutes or whatever is up for that one, and do the next one, so that you at least have answered all the questions. And as I say, you will have more marks in the beginning of a question. For instance, the intestate question, you might get 11 marks for what you've done there, where you would have received 2 or 3 in the estate duty. So my suggestion is start with whatever you are best at. But please look at the time limit. I've often seen this, that students say, but I know how to do the estate duty. Yes, you do, but you don't have enough time now. So now you take your time for your theory question, which you might have been 100% correct, but now you don't have time to answer it. And it might just be that 4 or 5 marks, even 1 or 2 marks you need to pass this examination. So spacing your time is quite important.
Thanks, Ms. Johnson. I've got one more question here, but this one is for you, Osmegi, and then I'll come back to you, Ms. Johnson, just for your final comments on paper 2. The last question is, okay, the person says a bit out of context, but I'd like to know if I can sit for conveyancing exams without completing articles, but with only 6 months PVT school, as is the case with the attorney's exam. Osmegi?
The candidate cannot sit for the conveyancing examination when she has not done his admission exams. Thank you.
Well, good. I think before we move on to the next speaker, Ms. Hajira Kara, Ms. Johnson, if you can make your last comments on paper 2.
Okay. Once again, study hard, be prepared, practice, practice, practice. The only way that you are going to be able to do the paper in the examination is if you practice now. Don't think that you know something. Make sure that you know something. You are definitely going to get a wills question. You are going to get a L&D question. You are going to get an interstate question, and there will be theory questions. Study hard. That's my only always go back to the basics. If you don't know the answer to something, go back to the basics. You'll see you will work it out from there. And good luck, be prepared, and then you'll be much calmer when you write the examination. And I promise you that this is a very fair paper. I can really assure you it's a fair paper, but even a fair paper needs a lot of preparation to answer it. Thank you, Kabelo.
Thank you so much, Ms. Johnson. And a reminder to candidates that if there are any general questions to do with the exams, you can send an email to info@lpc.org.za. Please just mark it that it's regarding exams so that the team monitoring the LPC emails are able to allocate it accordingly. At this point, I'd like to now hand over to Ms. Hajira Kara to assist us and take us through paper 3. Ms. Kara, over to you, ma'am. I think you're muted.
Good afternoon, Kabelo. Thank you very much. I am Hajira Kara, and I am going to give you some guidance on paper 3, which is your attorney's practice. I'm now going to switch off my camera, and without having to repeat what my colleagues have said, but just to reiterate some important points. The exam is an assessment. It assesses you as a practitioner who's new and coming into practice. Now, this is predominantly assessed in paper 3 because unlike your other papers where you have a structured answer, for example, in an L&D account, you have to put something in a certain way to receive a certain result. It's the same with bookkeeping. And to a certain extent, in paper 1, you cannot do a summons where you are expected to do an application. Now, in paper 3, it works a bit differently. And maybe this is the part that actually has candidates always doubting themselves or maybe questioning the way they are answering the questions. From experience and from marking, what we have found is that candidates don't assess the questions properly and apply their minds to the answers. But before we get to that, let us look at some logistics in terms of how you prepare. Now, first of all, the mindset, and my colleague before me said now, you have only 2 enemies, one being yourself and of course one being time. For me, I'm going to concentrate on the one being yourself. It's actually your mind that is your enemy. You go into paper 3, think all negative. This is the exam that makes me fail. This is the exam that's difficult. This is the exam I don't like. It's that approach of yours that needs to change. So the way you approach the exam is important. Yes, you cannot write on the left-hand side. You can make your notes. I'm not sure if one of my colleagues mentioned this. I've heard what they've said, but you must not use correction tape because the parts that you write over correction tape are also not marked. So rather strike it off neatly and put your answer again. Legibility of writing is also important. We try as best we can, markers try as best they can to be able to see what you have written. And we appreciate that you are writing under pressure, you are writing fast, but practice when you are practicing your skills and when you are practicing answers, try to write in a way that you know at the least somebody can read what you have written. Now, you also need to be kind to yourself. You cannot overburden yourself because one of the challenges you have with paper 3 is the content. There's a lot of content, and you try to overburden yourself, trying to SWOT principles, trying to memorize things. And sometimes you burn yourself out. So you come to the exam tired. And sometimes you also are too tired to understand a concept, but you push yourself to study more than you should be studying on that specific night or the specific day. So be realistic in what you are doing. You also need to focus on your health. So you need to have a good sleep, you need to be hydrated, you need to eat well, and don't learn new things in the sense that I want to paraphrase it. Understand the concepts, make summaries for yourself, understand what it is you want. Try not to overpack yourself with information the night before. I've heard candidates say that I looked at this just before I went into the exam and I'm glad I did. I'm glad if that actually works for you, but it's not something you must depend on. Don't leave things for the morning of the exam and say, I quickly need to look at this because I haven't studied it before. If you do that, you are not going to familiarize yourself with it, and you will end up in problems in the exam. Now, your 3 core structures are your Legal Practice Act, your Code of Conduct for Legal Practitioners, and the rules of the Legal Practice Council. Now, when I look at the Code of Conduct and I look at the Legal Practice Act, what is it saying to me as a practitioner? It's saying how I need to behave as a lawyer. What is it that I need to do? How must I carry my practice? When you write this exam, you must look at yourself and put yourself in the position of a small to medium practice. It is my practice within a practice. I often hear candidates say, why do we need to do bookkeeping? Why must I worry about trust money? That is done in the accounts department. I don't do that in a law firm. It is your responsibility. It is your responsibility what happens with their client's money. If that money is stolen, what must happen in terms of your law practice? What must happen in terms of the code of conduct? Those are the kind of concepts you need to understand. And that is where the ethics plays a role. So when we talk about assessing, your ethics exam or this attorney's practice is basically like a nuance exam. When we say nuance, what do we actually mean? We mean that when you look at this, you have to basically, what we are doing is we are trying to see your judgment, your reasoning, and your understanding of a concept. So I don't give you a straightforward question and say, what's the consequences of if a matter prescribed? We say to you, you had an office, and in your office there was a matter that had prescribed. How do you go about attending to this? What are we testing? Your judgment. First of all, the matter prescribed at your office. That is wrong. It should have never prescribed, first of all, and second, it's at your office. The reasoning behind it. What is your reasoning now in terms of the matter that prescribed? Are you taking accountability? What does the rule say? What does the act say? What does the code of conduct say? Must you take accountability for this? To what extent? And of course, understanding what the next process is. So when there's questions in ethics, they don't all have clear cut out right and wrong answers in terms of your assessing it. But they do have clear cut out principles in terms of the code of conduct. And that is the core of your answer. So how do you approach these questions? You go, you look at the question, you take out the facts from the question. So you go with a highlighter, you highlight things in the question and give yourself time. Sometimes your mind is your biggest enemy. In your reading time, you look at these questions, you are stuck with the question in your mind that you can't answer or that you don't know. And then you compromise the answers that you do know because that question's working on your mind. So highlight everything in terms of what questions are giving you. Make your notes next to it, or in your writing pad where you can make the notes. Say this question relates to this principle, this one relates to this principle. Then answer your questions based on what it is I know better in terms of my answers, and then come back to those that you are unsure about. Then consider them. Think about yourself in that position. If I am a lawyer and I am put in this position, what am I going to do? What is expected of me? So you need to look at your duties as a lawyer, you need to look at the conduct, you need to take the situation requiring your discretion, but you need to couple it with a professional judgment. That's what you need to do. And that is what is tested in terms of your ethics. So when it comes to straightforwardness, all questions wouldn't have a straightforward answer. But the principle in terms of the straightforwardness is what is embedded in your code of conduct, in the Legal Practice Act, and that is what you need to take and then align it to the set of facts you get. It is also important not to change facts. You must take into account this is what the questioner said. I need to align my answer to this. Now, we don't expect you to quote in terms of the code of conduct or the act that this rule number says this or this section says this, but you will see that your syllabus guides you in terms of the sections that you need to read, in terms of understanding what they mean, and in terms of applying. Your exam for attorney's practice is an assessment, it is based on application. Now, there's certain concepts. So, for example, you have like a conflict of interest, you have confidentiality or legal professional privilege, the ethical duties of the attorney related to the profession in the code of conduct. Now, my conflict of interest, for example, can very easily fall within the ambit of my ethical duties. So when I assess something and when I answer it, I cannot just tick off one principle and say this is the principle that is applicable. It's a principle that is embedded in different principles. So that's what I need to understand and that's what I need to address. Look at your mark allocations when you get a question and look at how much is expected of you. Now, where you see, for example, there's 2-3 principles that would be applicable, mention them, state them, and understand what they mean, and write it in a way that your examiner can see you understand the principle. If you are asked a question that says, explain a principle, don't explain it by giving an example, because the question says explain the principle. So explain what you understand that principle to mean. And then if you feel I've not explained it well enough, I want to complement it or supplement it with an example. Sometimes questions even say to you, we don't want an explanation by purposes of an example. So read your questions carefully to understand what it is that they mean. There's certain Latin terms, and I'm speaking across now the other papers as well, that you know, for example, like locus standi, or in terms of your estates, your fideicomissum. But when it comes to understanding and explaining ethics, you must be able to explain it in simple words. We don't want you to have to explain it in a sense where we're looking at the kind of language you are using. It must be understandable. It can be simple and straightforward, provided you are giving us the principle and you are applying the rules of law. And that's what the test is basically about. You also need to guide yourself in terms of your study material. Now, unfortunately, if I give you an example, for example, it is in your bookkeeping, for those of you who are writing, and it's now accounts management, that you are not allowed to have a deficit in your trust account, for example. And now how do you fix it up? You need to take money from business and put it into trust. That's your accounting principle. But what is your ethical principle? I need to report this to the LPC. I need to say to them that there was a deficit. I have fixed it up. That is the ethical part. So nothing that you do in any part of law doesn't have an ethical component. And maybe that's where your burden comes from. Because when you study, you want to separate paper 1, you want to separate paper 2, you want to separate paper 4, and you have this notion in your mind that certain of these principles don't have to apply. Now, yes, we are not in paper 3 going to tell you draw up an L&D account, but these sort of principles which can have an attorney being liable or accountable, a legal practitioner, is what you must be able to to take from that. And that is what the test for you is in terms of that. Now, we are governed by regulatory bodies. We need to understand what those regulatory bodies put in place for us in terms of our code of conduct, in terms of understanding certain principles, like, for example, your conflicts, your disclosures, your sharing of officers, and that relates to the semantics and the attorney in terms of their behavior and their practice. Now, you have different other subjects that go with it. And the reason these subjects even go with it is because when we look at the attorney's practice, and as I've mentioned, these must, your practice basically can evolve around different subjects and different parts of law. But think about it. All attorneys at some point or the other look at a contract. Okay, so I mean, that is supposed to be part of what you do as an attorney. Now, when it comes to my ethics and when it comes to the principles, that is what I'm going to do. I'm going to apply those principles from what I understand them to mean. Now, let's go look at our different subjects. If I look at constitutional practice or I look at the aspects of customary law, I need to know that there's a Bill of Rights. What does this Bill of Rights say? It gives me as an individual certain rights. How are these rights enforced? And if there is a contravention of this, what is the test? What must I look at? What must I take into account? It's again practical application. However, in any of this material, I cannot apply it practically if I don't know the theory. So I must prepare. I must use my study material. I must prepare. And unfortunately, if I don't prepare and I cramp it, I will not be able to apply it. So in terms of our constitutional and customary law, you have to see which sort of matters it is the Constitutional Court can hear, how they address these matters in terms of the jurisdiction, the accessibility to the court. In terms of your customary law, you take into account land, customary marriages, succession, ownership of property. They refer you to a Bay judgment that is interesting to read. It's good to read it to understand the principles in terms of what the regulator is conveying to us. If you look at, for example, the next one, which is your labor dispute, here you need to look at basically what does the Labor Relations Act say, what does Basic Conditions of Employment Act say in terms of the processes related to labor. So dismissals, disciplinary processes, notices, warnings, our conciliation, arbitration processes. When it comes to arbitration, of course, we know also that you can have an arbitration clause in terms of your drafting of contracts. So there's a certain overlap in our study material as well. An alternate dispute resolution basically is also covered in terms of your courts because you have your Rule 41A mediation. You see at this point in time, attorneys are leaning towards mediation or they're trying to resolve matters. Courts want us to implement mediation because of the backlog that there is. So we must understand that there's an alternate dispute process. Now, you would probably be asking, but why must this be here and why is it not in courts? Because what is my ethical duty as a lawyer? If I can see that a matter can be settled without having to go to court and without having my client incur all that unnecessary cost, I have a duty to do that. Where does the duty come from? It comes from my duty to my client. It comes from my duty to the court. It comes from my duty in terms of uplifting the interest of promoting the interest of justice. So that is how I apply that principle in saying to my client, let's do conciliation or let's do mediation. And then I need to take into account the factors that would basically affect things like this. Is it worth it for me to go and charge my client an exorbitant fee just because I'm getting a fee and I can get a matter prolonged at court? Is that really what the system wants from me? Or if I can settle it at a point before that, do I have an obligation to do so? Now, if you go to your code of conduct, you're going to find nothing in there that says to you, you must advise your client of negotiation, conciliation, mediation. But the code of conduct says that I must do whatever I can to assist the client in the best way possible. So what is the best way? The best way is trying to find them a solution which can work for them. And if there is a solution that can work that is cheaper and faster, I need to advise the client. If the client elects not to take it, that is for the client to decide. But that is my ethical duty, and that is what we test you on. Now, when you come to matrimonial property law, we have to look at, of course, the marriages, the different types of property regimes, the different acts that are applicable in terms of your divorce, your matrimonial property, your maintenance act. If you look at the previous exam that was written, there was a question on it in terms of which we asked, can you in the midst of a divorce, can a spouse claim maintenance? And the question specifically referred to regional court, which means that the answer should have been a Rule 58. Many people went and wrote a Rule 43 because they didn't take note of the word regional. And that is why I say highlight your questions, look at the facts that are given in them. We have this tendency, and it's the mind that works like that. You look at something and you say, oh, I know this. But you don't read the entire question, or you read it summarily, you proceed to answer other questions, you come back to it, you see you're running short of time, or halfway through the exam, you're already so pressurized that you omit some of the important things. So use your 15 minutes constructively, highlight what the questions give you, understand what they are saying, and even after the 15 minutes, if you need to take 5 or 10 minutes to make your notes and understand what they are saying, do that before you actually race into the exam, miss out these words, and then not answer questions correctly. Now, we know that the best interest child principle, for example, comes with the fact that the family advocate is seen to be there to look over the best interest of children. Court is considered as the upper guardian of minor children. Again, this is intertwined with ADR, and it comes back to my principles in terms of application. So that is what we need to take note of also when we consider matrimonial property law. Of course, we need to consider the fact that you have various aspects in it. So you have your maintenance, you have your how do I serve my summons, my particulars of claim, the customary marriages and Muslim marriages and the status of those marriages, the key, contact, and primary residence of minor children. Now, you find that, for example, in matrimonial law, and even for those of you who are not in practice, what we must absorb is that certain words have certain meanings, they have certain connotations. And I must clarify this because I don't want to look like I'm contradicting what I've said earlier. When we talk about minor children, for example, we talk about care, contact, and primary residence. And we know those are the words that we need to insert in our documents that must go to court. Now, I must be careful about things like that. I must be careful when I'm studying, when I look at pleadings, when I look at matrimonial property law, and I look at what is expected, that there's certain words that must be there because that is in terms of prescribed legislation. It's in terms of the Matrimonial Property Act. It's in terms of identifying what is a primary residence for a minor child. It is what the family advocate is going to endorse, understanding what a primary residence is. So I must take note of those words because they apply in terms of certain principles. Then we come to your legal cost. And of course, your legal cost again has far-reaching ethical issues. Reasons being because of the fact that many attorneys are before the LPC because of charging incorrectly, either because they overcharge, they undercharge, they don't give people accounts on time. So why does this actually happen? And what is the struggle in terms of which this happens? This happens because sometimes people don't understand the different principles in terms of what we're explaining to them. And that is why it is important we have an ethical duty to be able to explain to a client how cost structures work, what it is that we need in terms of cost structures, and how it is that these are actually explained to clients. Now, everything, of course, starts with your mandate and your fee agreement. This was also a question in the exam where they asked, how do you have a mandate fee agreement? What is my ethical duty as a lawyer? My ethical duty is to service a client, but at the same time to ensure that as a lawyer, you cover your back. You have these things in writing. You explain to clients. You never assume if a client comes, they understand everything because they don't. So we must understand it in order to explain it to them. And there is no lawyer that can ever say, I'm not going to deal with costs. because you are going to deal with costs. You don't only deal with costs in terms of litigation, in terms of your court practices. You don't only deal with costs in terms of estates or in terms of bookkeeping. You deal with costs in terms of fees, in terms of what I'm charging my client. And that is a huge responsibility ethically. And this is where we assess this again. And when we assess this, you need to understand the principles of cost in order to apply them. My application is my assessment, and my principles is my theory, which I must understand. I cannot apply something if I don't know the theory that is behind it. So we must take that into account. We also need to take into account that these days you have a public that is much more amenable to understanding these and to taking on lawyers in terms of saying, you didn't explain the process to me, you didn't charge me properly. It's the same with the process. And that comes to your ethical part. On paper one, you write a letter of demand. After your letter of demand, you know you're going to issue a summons. A client can very easily say, I didn't know that after writing a letter of demand, the next process is issuing a summons because you never explained that to me. So that comes to your ethical part. What is your ethical duty to explain what's going to happen in these matters to a client, to give them an idea, to say to them, I cannot guarantee you the outcome of a matter, but this is how it would work in the normal course of events. If there is something different, this is how we deal with it. Now, you must know the different types of cost orders in terms of what they mean, because how do I explain this to a client if I don't know what it means? How do I know I'm acting in the best interest of my client? If the court makes an order in terms of cost that I'm not happy with, I must be able to dispute it. I must be able to go to court. And when you draft your particulars of claim, sometimes you charge costs on a certain scale. How am I doing that? Where do I get it from? What makes it okay for it to be there? I need to understand those principles. When we come to our drafting of contracts, it's important to understand that it is true that you might say, I've not drafted all of these contracts in my life, so I don't understand them. You need to understand what the principles in terms of drafting are. So, for example, if I have a contract, what makes this contract valid? Must it be in writing? How do I get a mandate to draft this contract? If I'm represented by juristic entity, who signs this contract? How am I going to address anything that comes in a contract? And I always say one of the most important principles when you are drafting is look back at it and say, if I was a judge and this came before me because there was a dispute on this paragraph, did I draft this paragraph sufficiently so as to say that I try to minimize the room for disputes? Remember this, people can raise disputes over things all the time. And we're not saying what we draft doesn't create a dispute, but have I drafted sufficiently? So my principle when I'm drafting must always be, I don't want to be that attorney that lands up in a situation where the court looks at this paragraph or this contract and says, but which attorney drafted this? I want to draft documents that are good, that are understandable, and that apply the ethics in terms of drafting. So similarly, you have a client who comes to you who is unrepresented. And what is my ethical duty in terms of that? If that person, I have two parties to a contract, I'm representing one, the other party is unrepresented. So what do I do in terms of that? My ethical duty, can I force them to sign a contract? Can I give them legal advice? And over and above that, when I'm drafting, what is the principles of law? What are my principles in terms of a sale of business, in terms of letters of demand, in terms of cancellation of agreement, in terms of my conditions? What are my principles? Because I must understand the principles in terms of drafting these clauses, and I must be able to apply them to the set of facts. You cannot have a paraphrase understanding of something and you cannot apply it to a set of facts because that's how it works in practice. Every client that comes to you comes with their own needs. But my principle in terms of certain things, I must understand it so that I can draft it according to that. So that's what we must take into account. Of course, you have certain clauses like your boilerplate clauses, which are going to be the same in all types of contracts, and understanding which type of clauses I can change, to what extent I can change them so that they are still legitimate, they are still enforceable, and they still comply with the elements of a valid contract. Then I also need to take account of various legislation that can affect it, like my credit agreement, my National Credit Act, the Consumer Protection Act, and of course, We now have information technology that plays an important role, and with the changing of times, we are all now aligned to being exposed to cyber law and electronic communications. I mean, there was a time when contracts wouldn't be signed electronically. These days they can. And of course, we have the POPI Act, which talks about our personal information, how it is affected, to what extent it's affected, and the risks that come with this. When you have your business email compromised, interception of payments from trust accounts where money is stolen and we don't even know how it went out. But again, it comes back to the principle. If the money is stolen, it's out of my trust account. Who is liable for that? Me as the attorney. And that's where we need to understand it and proceed from there in addressing it. Now, in terms of practice management, we must also take into account that we are accountable institutions in terms of FICA. There's certain risks that are involved. We want to try and mitigate these risks because that's what a good practice does. And that's what we as attorneys are actually expected to do. So we need to look at the legal requirements for this, the regulatory requirements. What does it take for me to practice as an attorney? How do I go about being in compliance with the various regulatory bodies? Because if I'm not in compliant and I'm practicing, obviously I'm doing something wrong. And this here is the part that we as lawyers must know, because our regulatory body regulates us. The same way, if tomorrow you have a problem, that is some medical issue, or so what are you going to do? Go to the health professional board and report a doctor and say, you didn't do this right, and this is where I'm reporting you. The same way clients know they can go to the Legal Practice Council. So the council is our regulatory body. What do they expect of us? How do I mitigate the extent of liability in terms of insurances? The legal practitioners indemnity insurance fund, the fidelity fund. We need to look at these things and we need to basically study it. Now, I know a lot of the challenges come from the fact that a lot of times candidates say, but I am not in practice and I don't understand these things and I don't have exposure to it. Now, the truth of the matter is, even when you do articles and even in practice, after many years of practice, and my colleagues will confirm this with me, we are not always exposed to everything. But you must understand principles, and that's why we have guides, that's why we have study material, that's why we need to look at it. We need to understand certain kind of theory, and we must apply the principles that are embedded in us as lawyers, and that is what we must apply. So there's no question in the exam that you can't answer. And none of you need to undermine yourselves because you are a lawyer. You already have a degree and you know what it is to be a lawyer. You've studied theory already. So there shouldn't be any reason why any of you can actually not answer a question in the exam applying what you understand. And if you don't understand a question, practically put yourself in that situation and say, if I'm a lawyer, what am I going to do in this position? But you cannot go into this exam not understanding your theory and not having studied it. So, in terms of your preparation, you need to guide yourself with this material. But like I've said, don't ignore the principles that come from your other subjects as well. And if you haven't studied the theory, you won't be able to understand how to apply it. So it's imperative that both go hand in hand. Thank you, Cabello. I think that is it from me.
Thanks, Ms. Kara. There is quite a few questions and comments that have come through. And there's actually an assortment. There are questions going back to paper 1 and so on. So I'll read them and I'll ask the other presenters to come in, if the question refers to them. So the first one here, it says, okay, from the last paper, when we were required, on top of the clauses, the question wanted us to draft and mention as essentialia clauses. Were we required to include some boilerplate clauses? I cannot remember the marker location, but can the number of marks indicate this?
I'm not sure I understand the question correctly, but again, this is not like a revision session. But
Yeah.
if I can give you some sort of guideline, I cannot draft a contract if I don't know what are the essentiala, the naturala, and the incidentala. So I need to understand their theory, and when I understand their theory, then I will know what is a boilerplate clause, which is different from what an essentiala clause would be. So my essentiala clauses would be things that are essential, that need to be in my contracts, and my boilerplate clauses would be those which are more classified according to the um, common terms that would appear in every contract.
Thanks, Ms. Kara. The next two questions. One is insolvency part of our scope? And then the other question is, when it comes to drafting, how strict are the markers with a precise wording as per the lead manual, for example?
Okay. So insolvency is not part of your syllabus. And insofar as the drafting is concerned, remember there's different ways of saying something. So if today is a gloomy day, I can say gloomy, I can say overcast, and the principle is it would mean the same thing. So insofar as that is concerned, that we would look at it for the context of what it was asked in and what you said. However, if there are certain principles in terms of law, certain theory that you must specifically refer to, or certain words that you must refer to, then those would be expected to be there. And as you study, as you look at your different paragraphs and the different types of material that you are studying, you will see some of those words that are important to be there.
Thanks, Ms. Kara. The next question, on the aspect of drafting some clauses, on the aspect of drafting some clauses are quite lengthy, such as arbitration clause or domicilium clause. Do the markers look at the keywords contained in such clauses, or is it encouraged to write in our own understanding? I think you've alluded to this, but if you can just add to that.
Yes. Now you see, you can write in your own words, but your principles must all be there. So if you take, for example, an arbitration clause, I need to take into account the seat, the number of arbitrators, the language, the law that is going to be applicable, the cost. I must be able to cover everything that would be in an arbitration clause. So even though you are drafting it in your own words, there's certain key aspects that must be there. And because I've qualified this to say it's an assessment, when people mark, they don't only look for keywords, they look at how you have phrased it with those words. So you might have a keyword, but you've phrased it in a way that is not what the principle is in terms of that, for example. So, for example, in an arbitration clause, you say the costs are, for example, in the way you have drafted it, maybe you want to say that the cost of the arbitration will be will be paid by the unsuccessful party, for example, or that the cost would be determined by the tribunal. That's what you actually want to say. But then in your cost clause, you say there is no cost. Now you're using the word cost, but you're not addressing what will happen to the cost correctly. Then in that instance, that's why they don't look at the keyword, they look at how you used it. So there's certain essentials that must be in a paragraph. And that essentials addresses certain words, but those words must be in a correct context in order to be applicable.
Thanks, Ms. Kara. The next two questions, I will need Osmegi's guidance on this one, the more general questions, and I'll come back to you, Ms. Kara. Okay, one candidate is asking for paper 1, what is the mark allocation? The breakdown of the mark allocation across the different questions. That's the first question. And then the second question for you, Osmegi, is that the syllabus states 20 August and 21 August 2025. That is Wednesday and Thursday. However, the syllabus says 20 August, which is Tuesday. Can we please get clarity? So I think that's just confirmation around the dates. Asmegi, if you can come in there and guide.
Thank you. Paper 1 consists of 100 marks. It's a 3-hour paper. The exam will be written on the 20th and the 21st of August. It could have been a typo of the Tuesday. It's Wednesday and Thursday. Thank you.
Thanks, Asmegi. Ms. Karam, I think this is for you. Will we be required to prepare an allocator under legal costs?
So legal cost is part of your syllabus. And if you look at the syllabus and what it is saying, I just want to get that part in front of me. Remember, how taxation and related aspects would cover the allocator, and how would I be able to address issues about costs if I didn't know what an allocator is, the effect of it, and the consequences. So you must understand costs and you must understand all these principles.
Still on the question of marks, there's another question here. Are marks allocated for writing sections and legislation? For example, Section 1(1)(a) or the Divorce Act 70 of 1979?
No. Unless the question said to you, like, you know, what application, like in the previous exam where they said, what application would you bring in terms of which rule, then yes. But like this, you are not expected to know the act number and year. If you refer to, for example, the Divorce Act, it's enough.
Let me see the next question or comment.
Sorry, Kabelo, if I may just add to that, there's certain sections in terms of certain legislation that are applicable in terms of understanding certain processes. So, for example, if you take like a Rule 43 or Rule 58, I must be able to know that rule number because it's common and I need to know it to be able to say, this is, for example, what I use in interim maintenance. So then I must know that Rule 43 is for High Court, Rule 53 is for Regional Court, and I must be able to state the rule number then. I don't need to know the connotation in terms of the Act number in the year, but I need to know this is Regional, this is High Court, this is the rule.
Thanks, Ms. Kara. Please confirm how long will paper 3 exam be? Will it still be 3 hours or 2 hours?
I don't know if Ms. Kweke can assist. I think it is it's 9 to 12:15. It's 3 hours with 15 minutes reading time.
Thanks, Ms. Kara.
That is correct, Ms. Hajira.
Thank you.
Okay. The next question or comment is, if we are assessed on our professional judgment, then what criteria is used to mark us right or wrong? The answer must make sense in the discretion of the marker or be, should the answer be right from the perspective of the marker, or must the answer make sense and generally be acceptable in law?
So that's a good question. The thing is, if it is assessed, right, it is assessed based on principles that govern us as lawyers. And these principles are regulated. So when your examiner marks, they mark it based on you applying the principles of law. So, for example, I cannot represent a plaintiff and a defendant in a matter because that would be a conflict of interest. If you had a case scenario that gave you something like that and you had to explain that, it's not for a discretion of a marker to say, yes, but you know, you can or you can't. The principle is there. When we assess you, we assess the way you have addressed this and the application of the theory. So the assessment is based on principles of law that are there and that you need to apply. It's not like there are questions where there can be an answer either or, and based on your argument or your discretion, either or would be correct. Because you have a syllabus and you have study material that you need to use. So that is obviously going to be what guides the answers.
Thanks, Ms. Kara. Let me deal with the next two questions. In paper 3, can we be asked to draft a full text allocator? And then the next question is, would we need to state the section in the LPC that in the LPC Act that gives the example, or can we just refer to the LPC Act or Code of Conduct?
So basically, the allocator we've already addressed and answered as before. And when it comes to your code of conduct and the act, your syllabus specifically refers you to sections that you need to go read and look at. In the Legal Practice Act, some of it overlaps with your code of conduct. You must understand what the code of conduct is saying. So when it comes to attorneys, for example, there's certain things they say, like for example, you as a candidate legal practitioner, you have no appearance in the High Court until you are admitted. Something like that, you must be able to say, I cannot appear in the High Court if, for example, if there's a question like that. We don't expect you to know the section or the rule number, but you must be able to give us a reference to say, in terms of the code of conduct, I can't, I need to be admitted to have a right of admission. And have a right of admission.
Thanks, Ms. Kara. Let me see here. I've got two more questions before I check if there's any new ones that have come in, and then we'll go to paper 4. The second last question is, for paper 3, which syllabus should we follow? There is a notice 2685 of 2024 that was released last year on the 16th of August, which seems very detailed. And there is a syllabus released this year for August exams. It seems to have less details. Will we study sufficient information if we only follow the syllabus released for the August paper? Osmegi, would you?
Yes,
Oh,
sorry.
okay. Please go ahead, Ms. Kara.
I don't know, does Ms. Kwaki want to go first, or can I go?
Yes. You can go, Ms. Hajira. I will supplement if it's needed.
Thank you. So basically, your syllabus, if you look at what it was and what it is, insolvency is not there anymore. And in relation to the rest, both of it basically covers the same content. If you work on this August syllabus, it's a published syllabus, so there's not going to be something that is not in the syllabus and that you will be asked about. I don't know if Ms. Kwaki wants to add on something, or are we good?
We are good, ma'am.
Thanks, Osmegi. Thanks, Ms. Kara. Okay, the next question is, what happens if I've passed 3 papers and I happen not to pass the 4th paper regarding the changes that will be taking place as of 2026? Oh no, I think we did deal with this one previously. We did deal with that question. Let me just go back and look at the new posts now that have just coming in. Okay, since insolvency is not in the syllabus, does that mean Section 34 notice is also excluded?
So Section 34 basically relates to the sale of a business. Insofar as the sale of a business is concerned, that is one of the requirements that must be there. So your sale of business is part of your contracts. It's part of your study material. So I cannot sell a business and not explain to a client the risk in relation to that. So that I need to know. So when we say insolvency is excluded, we mean it's excluded in the sense of what is the process of insolvency, what is the process of business rescue. All of that is excluded. So your manual in terms of insolvency law that you have, and it relates to those things. But Section 34, unfortunately, would fall under a sale of business. It's one of my prerequisites. So I need to know that.
Okay, thanks, Ms. Kara. Will trade unions be asked collective bargaining is not part of the syllabus?
So if you look at and again, if you look at what the syllabus is saying, it says in terms of your labor law and in terms of your manuals that you have, dismissals, disciplinary processes, notices and warnings, procedures and implications for strikes and protected strikes and lockouts. And it refers you to the acts. So it refers you to labor relations, basic conditions of employment, unemployment, and occupational health and safety act. Now, if I want to do collective, and it talks about unfair labor practices and remedies. So, I mean, a trade union strike could be one that is a protected strike, could be one that is unprotected. The procedure and implications for strikes is there, it's included. And when we talk about collective bargaining, it falls under within the ambit of what the scope of your studying is, and it is also within your prescribed material. So you need to know these things. You cannot look at your syllabus and read it only for what it's saying and tick it off and say, okay, I've now looked at the procedure and implication for strikes, whether they're protected and unprotected and lockouts. Now it means collective bargaining isn't here, I must ignore it. But it's covered in terms of the prescribed legislation as well as in terms of your material, and it would fall in terms of classification under one of these. So you need to look at all your different topics the same way.
Thanks, Ms. Kara. Before I move on to the next speaker, Ms. Tarwa, Maggie, Ms. Kwacha, I would, when we close this session, could I ask that you just maybe go through again what the implications of having the paper 5 next year are going to be, especially for students who've written this year. The reason I'm requesting that, Maggie, is that that question keeps on coming up on the chat. So we would appreciate it if you maybe at the end, you can just re-emphasize what the implications are, how people who've maybe not passed or who have modules outstanding, how they will be affected. And also something else that keeps on coming up is just confirmation of dates for the exams, which I know you did answer earlier. But perhaps at the end, we can just re-emphasize, as I suspect some of the candidates may have joined late and may not have heard you. I do ask the candidates to continue posting the questions. If perhaps there's any question I missed, please do post it again, and then we'll go through the questions again at the end. At this point, I'd like to...
Sorry, Mr. Kabelo,
yes,
I'm
ma'am.
sorry to interrupt you. Before you go on,
Please
can
go
I
ahead, ma'am.
just get
Yes.
them closing? Sorry.
Please do.
I understand your questions in relation to the syllabus and the exams, but that is exactly the point I was making. For those of you who are not writing all the papers, I would presume that question is a valid question. And for the rest of you that say, if I don't make it, that should not even be in your mind. The fact that you already feel like that is where your mind is your enemy. You have done these subjects in undergraduate. So there should be no reason why a syllabus must intimidate you or course material must intimidate you. So I do believe each one of you can pass this exam. You need to study hard. You need to apply your mind. Think like a lawyer. This exam is almost like a postgraduate, and your law degree must be seen as your undergraduate. So when you do this, you must apply it. You must understand the principles. You must study the prescribed material. You must understand different concepts and study hard for it. And don't even ask yourself, what if I don't make it? You shouldn't be there right now. And the material is not too much for you to learn, because some of it, what you do, is a repetition and a refresher from what you have done at university. You passed it there, that's why you're here. So you are capable of passing this. You should study hard, and I wish you all the best. Thank you, Kabelo.
Thanks, Ms. Kara. Just as I was about to ask the next speaker to come on, then the Q&A floods again with questions. So if you don't mind, if you can bear with me, maybe I'll just quickly go through what has come in, just so that
Okay.
I'm not rushing to the next paper. We still do have time. Okay, so first question, is case law important for paper 3?
If you look at a case in a matter and you, for example, don't remember a name but you want to make the principal, you can say in a prescribed case. And if you do remember a case and you want to refer to it, you can. But there's no cases, and there is this paid judgment, which is a recent one, which you must look at in terms of understanding principles. Your material does have prescribed cases and principles that come from it, especially in your ethics guide. There's a lot of case law that says this was what happened in this case. The principles are there. So if you don't remember the case, you can just say in a prescribed case. And if you do remember the case, you can refer to it.
Thanks, Ms. Kara. Okay, there's a question here. Where is the August exam syllabus accessed? The answer is the website, and there was a notice. However, if any candidate is struggling and is not able to access it, they can drop an email at info@lpc. Make it clearly on the subject that it relates to the exams. And between myself and the comms team, we can just ensure that we've responded and be guided by Ausmegi Gwache's department as required. So those candidates who are not able to, who could not find the syllabus, they must first check on the website and then they can drop an email for us to assist. The next comment or question, must we be able to draft the warnings, disciplinary notices, and all process documents herein? Does that make sense to you?
Yes. So basically, this exam is based on theory and drafting. You will find there is a 60% of your paper actually is drafting, 40% is more towards theory. So it means you must be able to draft and you must understand theory. You must be able to draft across the board. Any drafting question can be asked in terms of your prescribed material.
Thanks, Ms. Kara. Ausmegi, the next one is for you.
Sorry, Gabino.
Sorry.
Like the previous question about the allocator is also drafting. So it's all drafting. You must know in the different subjects, whatever drafting includes, you must know. Like in matrimonial, they have your syllabus is a plea, particulars of claim. You must know the drafting. Thank you.
Thanks, Ms. Kara. The next one is more general. How does the LPC come up with the venues? I believe they're not considerate of candidates when they select venues. Ausmegi, I don't know if you want to respond to that now or if you will deal with it later. I do know the cost and centrality matters and numbers and all that. I know there's some...
I think I will answer the question now, Mr. Letebelo.
Please go ahead.
When the LPC appoints venues, we consider the numbers, number one, because we have to consider, we consider a lot of factors. The numbers of the candidates that are writing, as well as the budget. Unfortunately, it would be impossible for the LPC to consider each and every candidate. Hence, we don't just have one venue. For bigger provinces like your Gauteng, we have multiple venues. And we do consider that students in Pretoria must be written in Pretoria as far as possible. Thank you.
Thanks, Ausmegi. And then the last question that we'll deal with before the next section is with regards to paper 3, will the exam consist of short questions across the topics, covering most of the topics, or will the questions be more long type of questions and drafting specific contracts? Is there a larger portion to drafting or more practical questions applying legislation and theory studied?
I think we've answered this question in many ways already, but you need to know how to draft, you need to know how to apply, and you need to know theory. So for example, if you don't know the application or you don't know the principle, you won't know how to draft. And if you don't know how to draft, you're not going to apply the facts to that drafting. So you must know the theory, you must know how to draft, and you must know how to apply it.
Thank you so much, Ms.
Thank you.
Kara. I know you did make your last comments as we close in this. Is there anything else you wanted to add?
Nothing. Thank you so much.
Thank you so much, ma'am. And I think with all the presenters that are still on towards the end, if there is any other point or tip that you want to share, we can do that before Ms. Kwache closes the session. But at this point, I'd like to invite Ms. Tarwa. Ms. Tarwa, I hope I'm pronouncing your surname correctly, ma'am. You'll correct me if I haven't. Welcome. I'd like to hand over to you to cover paper 4. Thank you, ma'am.
Thank you, Mr. Letebele. Good afternoon, Ms. Kwake. Good afternoon, colleagues, and all the candidate attendees that are here present on the platform. I think you've all seen my face. I'm going to switch off my camera and then we get right into it. Thank you. I'm going to be discussing paper 4, in particular the exam preparation for bookkeeping. And as mentioned by the other examiners, this is not a revision session, but just to highlight the important sections that the candidate attorneys need to be aware of and prepare for the upcoming exams. And I'll also touch on the important topics as we go along. But first and foremost, I would really like to mention at this point in time that the candidate attorneys need to prepare for this exam thoroughly with the aim of understanding the basic concepts of bookkeeping. So simply rote learning these concepts will not suffice, but you need to understand the principles of accounting. So in other words, candidates should be able to understand the basic accounting concepts in order to be able to use these concepts in keeping full and proper accounting records of a legal practitioner, in particular, the trust and the business accounts. Before I proceed, I would just like at this juncture to go through some general advice. I just want to say the paper is for 2 hours, 45 minutes. So 2.5 hours for the actual writing of the paper and 15 minutes reading time before you start the examination. And the paper consists of 100 marks, and it usually has 4 questions. I would also want to urge the candidate attorneys to please read the instructions carefully and make sure that you understand. And as mentioned earlier, please only use ink. We have had some incidences in the past where candidates have used a pencil, and if you do that, no marks will be allocated. If you have to write any rough work, you must do so on the left page where there are no lines. Please make sure that you have answered all parts of a question. So make sure you read the question properly. You can use a highlight marker to highlight the important sections of the question so that when you now answer that question, you must make sure that you have answered all parts of the questions, because a number of times you also get questions that have got 3 parts to the question. You must make sure that you have indeed answered all the parts. Secondly, please read the question more than once. So I would recommend read twice, Read it again for the third time, and as you highlight the important sections of them. Some people prefer drawing the columns for the various books of accounts before attempting to write. This is now an issue of a preference. You need to decide what you find it easier. So, for example, as soon as some people get, as soon as you are told to start writing, some people prefer to draw all the columns or the T accounts, or some people prefer to do it as they answer the questions. But you must decide what would be easier for you. When you are now answering the questions, when you enter the transactions, try to post in the ledger accounts and at the same time, because what we find a lot of times the students then forget. You enter the transaction, let's say, for example, in your book of prime entry, which can be your trust cash book or your business cash book. Then you forget to enter, to post the transaction in your ledger. So try to follow through what you need to do for that particular transaction before you go to the next one. So if you start with, for example, a journal, do the journal immediately, debit the ledger account that needs to be debited, and then credit the ledger account that needs to be credited. Kindly take note of your time allocation for each question. So the mark allocation can also act as a guide as to how much time you should spend on that particular question. And it's always advisable to attempt the questions that you are most comfortable with and end up with the difficulty questions. The exam is, like I said, it consists of 4 questions. There will always be a question on bank reconciliation, which will probably be between 10 to 20 marks. Then there will be theory questions, short questions, for between 10 to 20 marks. And these short questions can be on VAT, journals, FICA, which is the Financial Intelligence Center Act, etc. As far as your long questions are concerned, they can be on conveyancing or investment. You can also get a long question on correspondent, and which is usually combined with a collection commission question. And as far as the correspondent question is concerned, you can either be asked that you are the instructed correspondent or the instructing correspondent. So you need to be familiar with either of them. And this long question can vary between 20 to 40 marks each. Now, what I would also want to advise is when you get your paper, before you actually start writing, you can just list in pencil all the accounting books, accounts that you will be required to do during the paper. For example, you can just list it, and you use this list as a checklist after you are done with the question to say, have I done all the accounts that I'm supposed to do? So for example, you can just quickly write trust cash book, business cash book, your journals. You know you've got a fee journal, transfer journal, trust journal, your ledger account, trust ledger account, business ledger account, your investment accounts, which is section 86.3, section 86.4, your VAT account, your fee account, then lastly your LPFF account. So after you have done your long question, you can then use list to quickly check that you have done everything, because we find a lot of times the students forget to do some of these things, and because of that they end up losing marks unnecessarily. As for the correspondent question, it is imperative that students do not get confused between instructing correspondent attorney and instructed correspondent attorney, especially when it comes to accounting to the client. You need to understand which client or who am I accounting to, right? The other thing that I can also advise the students or candidate attorneys to take note of is there are what I regard as 4 important questions. So when you looking at your question, especially the conveyancing or the investment questions, there are 4 questions that you need to ask yourself before you start answering that question. So as you read the question, ask yourself, is it a cash transaction or a non-cash transaction? This will guide you as to which book of prime entry are you going to use. So all your non-cash transactions, you use a journal. Your cash transactions, you use your trust cash book or your business cash book. Once you have clarified that, the next question that you need to ask yourself is, whose money is it? If it is client's money, then you know I will have to enter the transaction in the trust cash book. If it is money for the business, then you know that you are going to use the business cash book. The third question that you need to ask yourself is the flow of money. Is money coming into the cash book, or is it going out? Is it a receipt or a payment? If it is a receipt, you are receiving money, then you know you must debit. If it is a payment, which means money is flowing out of the account, then you need to credit your cash book. Then the fourth question is, if it is a journal, you need now to ask yourself, whose ledger am I going to debit and whose ledger am I going to credit? So for me, those 4 important questions will be able to guide you as what you should do with each and every transaction. Now, I just want to look at the syllabus itself. What is it that you need to understand in order to prepare for paper 4? Candidates need to understand the fundamental principles of bookkeeping. And although nowadays most law firms are using programs to do their accounts, it remains imperative that as the legal practitioner, you will need to understand and be able to interpret and understand also what is happening in your practice. So the following things form part of your syllabus. You need to understand the double entry system and be able to post in your ledgers. You need to understand the various books of prime entry. You also need to understand the difference between your cash book, trust cash book, and your business cash book. You can either get short questions on these topics, so you must be prepared for both. Bank reconciliation also is very important, And you will always, like I said, you will always get a question on bank reconciliation. Collection commission, you also need to understand how it works. I will sort of say a little bit more later on when we break down each of these items and highlight what you need to know. Then lastly, you also need to know about the conveyancing and investment. You also need to know about VAT, in particular the input VAT as well as output VAT, and when one should register as a VAT vendor. You also need to know how to rectify a trust debit or a trust shortfall. Please, this is also quite an important aspect, especially when it comes to dealing with a trust money. There are also some acts that you need to make sure that you have thoroughly gone through them. The first one being the Legal Practice Act, Act number 28 of 2014, as well as the rules, in particular, the accounting rules, Rule 54, Rule 55, Rule 56, as well as Rule 57. The other act that you need to know and understand is the Financial Intelligence Center Act number 38 of 2001, which is commonly known as the FICA. And lastly, the VAT. You just also need to know the relevant sections. So now, going back now to the cash book. In this section, you need to understand the following topics. You need to know what a source document is. You need to understand the difference, like I said earlier on, between a trust bank account and a business bank account. You need to also be able to distinguish between monies received and payments made. You also need to understand the interaction between the bank account and the cash book. Hence, you are requested or required to understand how to do a bank reconciliation. You also need to understand how to write up and balance a cash book, to understand the purpose of reconciliation, bank reconciliation, and know what is a supplementary cash book and its purpose. So in essence, you really need to have a thorough understanding of this section, because in the exam, you can be asked to prepare a supplementary cash book as well as a bank reconciliation statement. Sometimes you can also be given the list of transactions in the cash book, as well as a copy of a bank statement. And you are required to start from the first step, where you start by comparing the transactions appearing in your cash book, as well as the transactions that are appearing on your bank statement. And from there, you need now to tick and then see which transactions are appearing on the bank statement and they are not on your cash book, and vice versa, which transactions are appearing in the cash book, but they are not on the bank statement. And then after that, you will be expected to be able to write a supplementary cash book as well as a bank statement. So that's as far as bank reconciliation is concerned. Moving on to the books of prime entry, which is your journal, Remember, it's your journal. It is your cash book. I've already spoken about the cash book. Now let's focus on the journal. So you need to understand what is a journal. And this you can be also asked as a theory question. You need to also know different types of journals. The common ones being your fee journal, your transfer journal, your trust journal, your business journal, and your journal. And you should also have a clear understanding of when to use which journal. Right. As far as ledgers are concerned, we have two types of ledgers. We have the trust ledger, the business ledger. You should be able to understand which ledger to use when. Obviously, when you are dealing with the trustee cash book, you need to post in your trust ledger, and you must create trust ledger accounts for each and every trustee creditor whose money you are holding in your trustee account. And with your business cash book, you must also have business ledgers for the different clients. So you also need to understand what is the purpose of a ledger account. Now, going on to investments. There are two types of investments. The first one being the Section 86(3) investment, where all the interests are paid to the LPFF. Then we also have Section 86(4) investment account. As far as this one is concerned, you need to have a written mandate from the client in order to invest the client's money, and 95% of the interest will go to the client and 5% to the LPFF. You can also be asked to record transactions, so you'll be given a whole list of transactions, and you must record these transactions first in the trustee cash book and post them and post in the various ledger accounts. And after that, you may be asked to extract a list of trustee balances. So please make sure that you are able to do that in the exam. The other section which is also quite popular in the exam is your VAT section, your value added tax. You need to know the definition of what VAT, what is the difference between the output and input VAT, who must register as a VAT vendor, and also how to calculate VAT. So, for example, sometimes you are given an amount which is inclusive of VAT. So before you can do your journal, you need now to first calculate the VAT amount that is included in that amount. And there is a formula. I'm sure all of you by now, you know the formula. It is 15 divided by 115 times the amount inclusive of VAT, so that you get your VAT amount. Sometimes you are given the amount exclusive of VAT. That it is important that you read the question carefully to see if you can easily determine whether the amount is inclusive of VAT or exclusive of VAT, and whether the practitioner is a VAT vendor, meaning that he is registered for VAT. And if the amount is exclusive of VAT, then you know you must add the 15% VAT. And if the amount is inclusive of VAT, I've already mentioned, then you use the formula to calculate the VAT portion of that amount. And this is quite important when you do your fee journal. Now, the other important section is your collection commission. It is a very small section, but it is important that you have a thorough understanding of what a collection commission is. When a practitioner is instructed to recover or collect a debt, he is rendering a service for receiving whatever amount that the debtor is going to pay, which can either be the full amount that he is owing, or the debtor can then decide to pay that amount in installments. So for this service, the practitioner is entitled to debit a fee over and above the other fees that he is entitled, and 10% of the amount collected is the collection commission, and subject to a maximum of 1,500 rand. Now, the collection commission, we normally like to combine the questions on the collection commission together with the correspondent question. It might not always be like that, but that's why it is important that you understand both these sections. Going to receiving of instructions, I just want to pause a little bit here and emphasize that candidate attorneys need to really understand the difference between an instructed correspondent attorney or legal practitioner, or an instructing correspondent and an instructed correspondent. So, for example, if your client is in Nelspruit and you are also in Nelspruit, and the client instructs you to maybe to do debt collection matter for them from a person who is residing, let's say, in Pretoria, it is important when you read the question to make sure that you fully understand who is who in that question. And what I find to be helpful is to draw a little diagram. So with the example that I've given you, just write a little block and write the client and the place where the client is residing. You can put an arrow, you write the legal practitioner, and then that legal practitioner becomes now the instructing correspondent. Then you draw another arrow indicating who is the instructed correspondent, as well as the data, so that when you answer the question, you sort of like have a clear idea of who is who. So the question usually says, you are the instructed correspondent. Now you need to understand what does that mean so that you are able to answer the question properly. With your correspondence, you also need to understand the fees or allowance that is allowed or which can be granted between the two correspondent, the maximum. That can also come as a theory question, or as you do a question on correspondent, please make sure you read the question carefully. The maximum allowed is a third, but sometimes the question can tell you that it's the practitioners have agreed on a 20%, or a 25% or 10% or whatever percentage they have agreed, please take note, because we see a lot of students in the exam question says 20%, but because they are so used to the 1/3, they then automatically use the 1/3, and then you do everything wrong. So it is very important that you read the question, and if you can, highlight where it gives you the allowance that the practitioners have agreed, so that it stands out, and you keep that in mind as you answer the question. And when you are also doing these questions, please make sure that you differentiate, or you are able to differentiate your fees charged. For example, receiving of instructions, issuing of summons, correspondence, or whatever the case may be. And as compared to your disbursements, you must know how to deal with these two and not get confused. The last section, which is if you are using your lead guide, the chapter 13, this is where also most of your theory questions come from. And we see that candidates have a tendency of not reading this section, and resulting with them not doing so well on the theory questions. So I would like to advise you that you must read this section, as it still forms part of your syllabus. You can get theory questions, and a mark can make a big difference. I mean, if you are sitting at 49%, that 1 mark can make you pass. So please, I urge you to read this section for the theory questions. I did speak about the acts. We also realize that a lot of candidate attorneys, they don't actually go and read the various sections that they need to know. They just rely on what is in the guide, but it is important that you also go to the actual act itself and make sure that you read all the sections that you are required to know. And this also applies to the other act, the Financial Intelligence Center Act, as well as the VAT Act. I think I have covered the most important things. And like I said, this is not a revision session, but to just highlight the important sections that you need to thoroughly prepare for the exam. This is a competence-based exam. We want to test you to check if you understand the work that you are supposed to know, and that you can apply it. So hence, most of the questions are actually scenario-based. So you'll be given a series of transactions, and you now need to apply the theory in order to answer the question. And as a practitioner, you need to understand what is going on in your practice. Who is owing you money? Which clients are you holding money on in your trust account? Which clients have you invested their money on their behalf, and so forth? So it is imperative. I know some big law firms, they do have like the accounting department or bookkeeping session, whatever you want to call it, and there is someone who is specifically delegated to deal with the bookkeeping. But as the practitioner, you still need to understand what is happening in your practice, and also to understand the financial statements and so forth. And if your firm is not doing well, you need to also identify where can you be, where could things be going wrong? What corrective measures do you need to take in order to improve the financial situation of your practice? So hence, bookkeeping forms an important part of the modules that you need to understand if you are going to in your practice. I just want also to go back to the 4 questions that I said. For me, I find it very helpful, and it usually makes it easier when you are answering the long questions in the exams. So the 4 questions, once again, you must ask yourself, is it a cash transaction or a non-cash transaction? And this is what will help you to decide which book of prime entry do you use. Do you use the journal that is for non-cash, or the trust cash book, or the business cash book? The second most important question is, whose money is it? Because remember, in your business cash book, you only enter transactions for, or it only deals with money that belongs to the firm. So you must have offered the service to the client, and that money is due to the firm. Then you enter the transaction in the business cash book. But if a client deposits money for work that you are still going to do, then that money does not belong to the firm. It must be deposited or entered into your trustee cash book. So whose money is it? Very important. Then you must look at the flow of money. Is money coming in or money flowing out? So money coming in, it's a receipt. You must debit your trustee cash book or your business cash book. If money is flowing out, it's a payment, then you know you must credit. And the last important question is, if it is a journal, so let's say with your first question, is it a cash transaction or a non-cash transaction? So if it is a non-cash transaction, you now know you must use your journal. Then you ask, whose ledger am I going to debit, and whose ledger am I going to credit? And I think with those 4 questions, if you feel comfortable, you should be fine for the exams. Bookkeeping is not something that you should be scared of. It's fairly straightforward, but it requires you to put in the effort and to practice. It is unfortunately not a subject that you can just read and you don't practice the questions. You really need to practice, and the more you practice, the more comfortable you are to go to your exam and answer the questions without really feeling intimidated. So yes, it really requires a lot of effort on your part, but if you prepare well, there is really nothing to be afraid of, as long as you know the basics. Everything else, it's about bookkeeping, it's about repetition. Once you understand the difference between a journal and a cash book, you understand whether you should do debit or credit. Really, it is just a repetition thereafter. So I think I will stop here and then now address the questions.
Thanks, Ms. Tarwa. Thanks for taking us through paper 4. And I do have quite a number of questions and comments on the chat. But I think that a good starting point, it's around clarity on FICA.
Yes.
I note a lot of comments by candidates saying FICA is not listed on the syllabus, and another candidate says FICA is listed on the syllabus, but for paper 3. If perhaps we can start with providing clarity, is FICA in the exam, and is it included in the syllabus? How should students be preparing regarding FICA? Thanks, Ms. Tarwa.
Thank you for that. I'm just going back to the latest syllabus. Okay. All right. I see it is not listed specifically for bookkeeping, but previously it was there as part of the bookkeeping. But it's one of the pieces of legislation that all candidates need to be very familiar with. Because it is important that in terms of the FICA, you should know who you are doing business with. And also in terms of record keeping. So they are not, for this exam, if I look at the latest list of topics, I see that it's not there. So sorry, I just included it based on the other last year's syllabus, but I see now, I realize it is not specifically indicated for this August exam. Sorry, my, I should say point of correction there.
Noted. Noted. All good. Let me then, Mr. Roy, then move on to other questions and comments. And I also see it's not only about paper 4. Just give me one sec. It says, okay, maybe let me pull in Ms. Kwache here, Ausmegi. There is a question that says, can I write my exam in another province and not in the province I registered in? As far as I know, okay, Ms. Ausmegi, please guide me on that question.
Thank you, Mr. Letevele. No, please, we urge candidates, do not go to a venue that you are not registered in. The primary reason for you to register is so that the LPC can accommodate you in terms of the venue, in terms of the scripts and so forth. Do not pitch at another venue, more especially when you did not make arrangements, because we will turn you away because there will not be space for you. Thank you.
Thanks, Osmegi. The next question is, if we state at the beginning of a long question, for example, trust cash book, hereafter referred to as TCB, can we then use this abbreviation in our accounts without being penalized?
Yes, candidates may do that. TCB simply stands for Trust Cash Book. So yes, they can use TCB. It will be acceptable.
Thanks, Ms. Terwa. Are we allowed to have multiple journals? For example, have multiple fee journals, open journals as we answer the questions, or must we have one long fee journal that records all transactions?
I think candidates here, they can decide if they want to open separate journals for each transaction or use a combined. But what we find with a lot of students, if they combine, they end up getting confused. So I would advise that they should use single journals. But if they do want to combine, it's still okay, as long as they just make it clear and easier for the markers to identify the different journals or the different entries for a specific journal. But at the top, they must make sure that they correctly identify the journal, so that they don't end up mixing what should be a transaction of a trustee journal and a transfer journal under one. They must make sure that they can put together the transaction falling under a trustee journal, and then they have another heading and then do all the fee journals. That should be fine.
Thanks, Mr. Harwad. The next two questions are largely on the same. I'll read them, but you can add if you feel there's any further information that you want to add, but they are along the same lines. Can we draft our accounts, be it journals, ledgers, etc., on the same page, or is there a specific way we need to draft same in the exam? That's the first one. And then the second one says, on the transfer journal, when you debit client trust ledger and credit client business ledger, second step, debit trust cash book and credit business cash book, does it mean that the money that goes on the business cash book must go on the first column, the DR side? Does that make sense to you, Mr. Ra?
If you can just repeat the question, I think I missed something there.
Okay. On the transfer,
we're talking of a transfer journal.
Yes. So I'll read it as it's written here. On the transfer journal, when you debit client trust ledger and credit client business ledger, second step, debit trust cash book and credit business cash book. Does that mean money that goes on the business cash book must go on the first column at the DR side, the debit side?
Yeah, the question is a little...
Okay.
Yeah,
maybe we can ask the candidate to just maybe rephrase.
Yeah, because now they're saying debit the trust cash book, that doesn't make sense.
Okay.
Because remember, you use a transfer journal when, let's say now you have done you have finished the mandate, you have done the work. Now you want to pay yourself, and you need now to transfer money from your the cash book to the business account. So you must first now do the transfer journal, where you're going to indicate which account are you going to debit and then credit. But now if they go on to say now debit the cash book, something is just not clear there.
Good. If the candidate can maybe just rewrite or rephrase.
Rewrite the question, yes.
Okay, all good. Let me read the next one. When it comes to correspondence accounts, so it's either we get giving or receiving instruction, or can they ask both?
No, I don't see a situation where you could be asked both. It will be one or the other. So that's why I kept on emphasizing that they must make sure that they know which one are they being asked, but it will never be both, because there's just no time. Remember, the exam, it's 2 hours for 4 questions, so we can't ask 2 correspondent questions in one exam. So it will either be you are the instructed correspondent, or you are the instructing correspondent practitioner.
Right. Let me see what has just come through. Okay. Can we draft our accounts, be it journals or ledgers, etc., on the same page, or is there a specific way that we need to draft same in the exams?
No, there's no particular or specific way, as long as your accounts are very clear. Then you can write them on separate pages, or you can write one after the other. I think candidates by now should be comfortable as to how they are going to do it in the exam, because you find sometimes they squeeze everything on the same page, and it becomes very difficult as an examiner now to mark. I think the previous presenter did indicate that you've got that exam book, it's got many pages, and there's no reason to squeeze everything on the same page.
Thanks, Ms. Tara. Let me see, next question here. Are we allowed to divide our right page answer sheet into two parts? I think you've alluded to that. Not sure if there's anything else you want to add.
No.
Good.
Because sometimes it's actually easier to have your trust cash book on the one side and your business cash book on the other side, and below it you start having your ledgers. It just makes it easier.
Thanks, Ms. Tara. The question of the half marks again. Do we get half marks in this exam in paper 4?
Yeah, I can't remember
Yeah.
off the top of my head, but most of the times it's either 1 mark or half mark, but that will be indicated on the question itself.
I think we may have dealt with the next question, and it's also a general question. What is the dressing code and which pen are we allowed to use? I recall that it's a black pen. Ausmegi, regarding the dress code, is there a dress code or not here? My understanding is that there isn't. Please
Thank you,
clarify.
Mr. Letebele. Yes, candidates are please requested to dress appropriately. You are going for examination. We have seen candidates dressing as if they are going to the beach, and you are about to enter into the legal profession. So please dress appropriately when you come to the examinations. Thank you.
Thanks, Ausmegi. Ms. Tarwa, the next question says, do we have to make provision and reflect the 5% allocated to the LPFF when it comes to Section 86 for investments? Or can we just make a note to say Section 8.4 investment has been dealt with in accordance with the relevant legislation?
No, they will have to indicate and have the LPFF account. Because remember now, depending on the question, if they do get both Section 86.3 investment as well as Section 86.4 investment, then they will need to indicate the 5% from Section 86.4, which goes to the LPFF, and then Section 86.3 where the whole amount goes. So they will have to, because remember, this is a competent-based exam. We want to see if the candidate attorney understands. So yes, they have to have the LPFF account indicating the amounts that will be transferred to the LPFF.
Thanks, Ms. Tarwa. The next question is, in a property transaction question where no dates are provided for amounts received into the trust account, is it incorrect to record payments, for example, transfer duty or estate agent's commission from the business account and only transfer funds from trust to business after registration? I ask because in some memos, these amounts are showed as paid from trust, even when no client funds appear to be available in trust.
So normally with a conveyancing question, the client pays a deposit, and that is usually recorded in the trustee cash book. And sometimes they then get a guarantee for the balance, which is not recorded. And then when upon registration, the balance of the money is then recorded in the trustee cash book. So when you pay the estate agent from the trust, you must make sure that the money is available in the trustee account. So I hope I have answered the question.
Thank you, Ms. Tara. I'm looking here. Okay, there are some questions to do with conveyancing. Is conveyancing not part of the scope. I do remind candidates that there is a session for conveyancing and notarial, but I'm not sure, Ms. Tarwa, if there's any specific aspects for conveyancing relevant to candidates.
As far as bookkeeping is concerned.
Yeah.
Okay. I think the candidates just need to understand the process of purchasing a property. So to make it easier to understand the transactions that then happen during the transfer process. For example, with the previous question, knowing when the estate agent is paid, they get only paid after the property has been registered and money is available in the trust account. And yeah, so most of the transaction will happen on the day that the property is registered, and it is crucial that they make sure that they understand the process itself. From the time that they receive the instructions, get the deposit, if they have to invest that that money on behalf of the client, they must know that process and which investment account in terms of which section. So, for example, with the investment account, we want the students to write the name of the bank, the section. If it's section 86.4 investment account, that has to be very clear. So it's an easy question if you have understood the basic principles of bookkeeping. Like I said, it's a more or less repetition to know which account am I debiting, which account am I crediting. So I advise the candidates to make sure that they familiarize themselves with all the transactions that happen with a conveyancing question. It's a pity this is just a revision, where I cannot or we don't have time to go into details of the whole conveyancing process.
Thank you so much, Ms. Tara. Let me see what has just
Sorry,
come
Kabel,
through.
if I can just add, if you can recall when I said they can have this list as a checklist, it will also help them in particular with the conveyancing question to say, I need a trustee cash book, draw your trustee cash book, your business cash book, your journals, you can, even draw or write a list of the journals that you are going to use, your ledger accounts, your section 86 investment, and so forth. So that when after answering this question, you can go back to the checklist and tick to make sure that you have done everything. Because we find when we are marking, a lot of students will forget, especially the LPFF, which deals with the interest. Then they don't have that account. The fee journals, sometimes they forget about the fee journals. So to just help them, this list can serve as a checklist to make sure that they don't lose marks unnecessarily.
Thanks, Ms. Tara. We've got 3 more questions, and then I will ask you to do your final comments and tips, and then we'll also afford the same opportunity to the other presenters before Ausmegi, Ms. Kwache, closes. Okay, sorry. As I'm looking at the next question, more comments come in. Okay, so the one that has just come in, how do I determine if I'm the instructing attorney or instructed attorney in a correspondent question?
Okay. With this one, you just need to read your question. So, and make sure you understand. So normally it reads like this: you are the instructed attorney, or sometimes, yeah, so sometimes the question is about the instructing correspondent. So the way the wording of the question is very important, because that is what you are going to use to determine whether it's you are the instructed correspondent or the instructing attorney. So it will say you are the instructed correspondent, and you have received the following instructions. Then you know that you are the one who has been instructed to do the work. So your client in that case is instructing a practitioner, and you will then be entitled to the allowance. So if the question says you receive a statement from the instructed attorney, then you know that you are the instructing practitioner. So really, it's just about the wording.
Thank you, Ms. Terra. Okay, then another one that has just come in. Do we lose marks for the whole question if we forget to mention an account, or do we get marked on the accounts we did mention?
No, you will only get marks on the accounts that you have done. It's not negative or marking where you lose marks for wrong answers. Yeah, so you only be marked on what the accounts that you have done.
Another general question, please kindly confirm the proof of registration to be printed is the one on the email with details of the venue where the candidate is writing. I think that's more for you, Osmegi. And before you respond to that as well, there was another similar general question. Oh, yes. So in addition to that, Asmegi, if you can also confirm that in the absence of an original ID, can a candidate use a driver's license as a form of identification?
Thank you, Tikabelo. No, a driver's license is not allowed. Candidates must bring an ID or a passport. That is what's allowed. The registration letter is a letter you've received from the LPC confirming your registration. The candidate is correct. It is the one setting out your exam number and the papers that you are registered for and allowed to sit for.
Thank you, Asmegi. I'm looking again if there's any question perhaps that I did not read out. Just before I here's one more. Ms. Tara, can I use 3 column instead of T column, or must I only use T column?
Candidates have got an option either to use the columns or the T account. But what I suggest is before going to the exam, the candidates must decide which one they are going to use. Because if they interchange, it might be confusing for them. So, for example, with your bank reconciliation, bank recon, you can either use the column or you can use the T account. So whatever they find easier is what they should use.
Thanks, Ms. Terra. The next question is as follows. When answering a question, can I have T3B and BCB on the same page and then have trust ledgers on own page and business ledgers on their own page, then have journals on one page but indicate that fee journal or transfer journal accordingly, then go back to my ledgers on previous pages to post the second entry?
I think we did deal with this question.
We did, or is it
Yes.
okay?
Yeah,
Okay.
I think whatever they find it easier, I mean,
Okay.
whether it's on the same, because just putting everything on the same page, sometimes it gets all squashed up and it becomes difficult for examiners when we are marking. But as long as they are comfortable paging the exam script back and forth, there is nothing wrong. And also, if they use that checklist, because if it's on different pages, chances are they might forget one of the accounts. But if you have your checklist, then when you are done answering the question, you can go back to your checklist and ask yourself, have I done all the accounts that I'm supposed to do?
Thank you so much, Ms. Tarwa. The next two comments that have just come in are more on a general basis. So, Osmegi, maybe, some of them, they refer to similar issues. One says, "Good day, I received my confirmation registration letter, which envisaged my venue. However, I did not receive additional information, confirmation of venue letter, but my colleagues did last week. I did email the LPC. I did not get the response. Will be an issue." So, Ausmegi, is that with regards to the confirmation of venues, maybe if you can just reiterate the exact confirmations that that the candidates would have received. And I think the candidate can, if that's still not clear, perhaps they can still, apologies, I note you did say you sent an email. I think if you can maybe just send one specifically highlighting that, this matter. But I think maybe before I suggest that you resend an email, I think the confirmations were sent out, Maggie. In what version would have the candidates have received them? Just so that we clarify to this candidate.
Thank you, sir. The confirmation letters of registrations are sent in the provinces, just as the registrations are also handled in the provinces. So if you have not received your registration letter confirming that you have registered from your province, please send a follow-up email. You are welcome to send an email to info@lpc if your province is not responding to you. Thank you.
Thank you, Ausmegi. Ms. Tarwa, there is another comment here. It says, according to our notes, the 10% collection commission no longer applies and there is no limit. It must just be a reasonable amount. Comment?
It's as far as I know, it's a 10%.
Okay. Noted. Let me see here. Okay, with regards to the proof of registration, we did not receive the proof of registration as an attachment to the email, but as the body of the email was, must we print the whole email? I would assume so, but I think issues around proof of registration, Osmegi did address them, and she can also just maybe address them if she chooses when she closes. Let me just see. I want to make sure I've not missed any other pressing matter before I let Ms. Tarwa conclude. Oh, there's another comment here. The confirmation letters indicate that we can bring a driver's license. Is that an error? So Osmegi can Osmegi, please bear with me. This does keep on coming up. So but you can deal with it when you close, Osmegi. Let me look. Oh, okay. And then the issue of 5 papers for next year as well, that keeps on coming up. Okay, from what I can see, all the questions that that have been posed, that have come up specifically to question 4 have been asked. Ms. Tarwa, may I ask you to conclude, just maybe re-emphasize or highlight specific points that the candidates need to bear in mind? After you, then I'll ask Ms. Johnson and Ms. Kara to also maybe just have 30 seconds to a minute, just maybe if they want to highlight any aspects regarding their papers. And then after Ms. Kara, then Ausmegi, it's over to you to bring the proceedings to an end. Thanks, Ms. Tarwa.
Thank you, Kabel. In conclusion, I would just like to encourage the students to prepare thoroughly for the exams. They must not be scared of bookkeeping. All it needs is a thorough preparation and understanding. The other thing I would also want to discourage students from only focusing on past exam papers, because we are not repeating any past exam questions. They must just use past exam questions for practice, so that they have a better understanding of the work and not only focus and memorize the past exam exams. And like I mentioned earlier, there will be a question on bank recon, so the candidate attorneys need to make sure that they have covered this section thoroughly, and regardless of how the question is asked, they should be able to answer that question. There will be a question on the conveyancing and or in investment. They must also be comfortable to answer that question. Correspondence, yes, you always get a correspondent question as sometimes together with the collection commission. And lastly, theory, they must just not forget this part of the exam, that there is also theory questions. With that being said, I would like to take this opportunity to wish all the candidates that are writing bookkeeping all the best. Examiners, we are not here to fail you, but to assess whether you fully understand bookkeeping. Thank you.
Thank you, Ms. Tara. Ms. Johnson, is there anything else you'd like to state? Final words to the candidates?
Thank you, Kabelo. I think I've said all that has to be said. Just to recap, remember that you have to know your work very well. You have to know the theory, you have to know the principles, and then you should be able to do that in application with a set of facts given to you. Time is of great essence. The only way you can conquer the time problem is by practicing it beforehand. Don't practice in your head. Don't think that you know something. Make sure that you know it. Practice by doing it on a piece of paper. Remember to take 3 black pens just to be sure. Take your calculator, take your ruler, ensure that you present a neat and tidy script. And then I always say go back to the basics. From the intestate questions we had, it proved that you have to go back to the basics. If you know the basics, you can apply the more involved type of information they will give you. And then I wish you all good luck. I can really assure you that it will be a fair paper, but as I've said, a fair paper also needs good preparation, and the examiners and the moderating committee for the estates paper, they are not there to trick you. They are definitely only there to see and ensure that you know and understand the principles of estates. So I wish you luck.
Thank you so much, Ms. Johnson. Over to you, Ms. Kara.
Thank you very much. I think from my side, I've also covered everything. In closing, exams are never easy. But what you need to appreciate is this is just one more step on your journey. You need to trust in yourself, in your preparation, believe in your ability, and stay calm under pressure. You get into the exam being very pressurized, read your questions carefully, apply your mind, and answer them generously. And to our organizers, thank you very much for today, as well as to my colleagues. And to you that are writing, I wish you all the best, and we look forward to welcoming you into the profession, so you need to pass these exams. Thank you.
Thank you, Ms. Kara. Osmegi, over to you to conclude the session. Thank you very much, everyone.
Thank you, Obutikawelo. I would just like to thank the presenters for availing themselves today, as well as to yourself, candidate legal practitioners, for making time to attend this session. I've received that I must address when the exams will be written. The exams for the competency-based exam, that is paper 1 to paper 4 for attorneys, will be written on the 20th and the 21st of August, meaning paper 1 and 2 will be written on the 20th, and paper 3 and 4 will be written on the 21st of August. Concerning the 5 exams, as I have said previously, the 5 exam question papers will come into effect August 2026. So next year, March 2026 or February 2026, when the candidates are writing the exams, they will still be sitting down for 4 papers. If you have written only 1 and you are left with 3, you will be expected to write the outstanding question papers that you have. The same counts for the 5. The moment we approach the 5 question papers, candidates are expected to be writing the question papers they are left out with. Like I have said before, the LPC will have a webinar after these exams. We don't want to confuse you as candidates because we know you are preparing for these exams as well as for other work-related matters. So, however, after September, we will have a webinar whereby we will be informing you how the 5 question papers will be working and what to expect from them. The 5 question papers is not a sum fact thing. The 5 question papers has been revised in terms of the syllabus and in terms of the Legal Practice Act, more especially Regulation 16 of the Legal Practice Act. And I've just been informed by my colleagues, I apologize, that a driver's license is also allowed as a form of identification for the exams. Good luck to all the candidates. Please be aware that today's recording will be made available during the course of next week for you to be able to prepare for your exams. Thank you.